number 31 is the infrastructure.
Or 31 of this supplementary or item 31 red petition number.
Red petition number.
Which list you are mentioning?
First list na
Under
First list.
first list.
12568.
Number 12568 by 2022.
All right. 31 disposal of info. All right.
Make of the list. Supplementary list fresh admission item number 1.
My lord, race admission item number 1, there are 2 cases tagged, and along with item number 51. 52, my lords. Mr. S.D. Das, senior advocate, is the amicus curiae in that case. In all these cases, I am supposed to file an affidavit on the in the matter of a policy decision of the government so far as
Boat capsizing.
my lord, boat cap, yes.
Boat capsize.
That
Now 10 years have passed, my lords.
yes, in your lordship may tag all the cases.
10 years have passed.
10 years. On
Yes, 13.
4th July, the order was passed. 4th July 2022. It's, I think, not
The
even
PIL is of the year 2013
but
and
the
14.
direction. So I pray that last chance may be given. Any Friday, your lordship may fix at 2 p.m. We will file because it relates to some policy decision, and we have to seek the opinion from the transport department also, because the all these things have to be organized by the nodal department.
States that
All the
separate
3
departments
petitions.
have to be consulted. One more chance might be granted to the state government to file its comprehensive affidavit. If the affidavit is not filed on or before 1st May 2023, cost of rupees 25,000 will be paid to the High
My lord,
Court.
your lordship may not. We undertake that we will file it on that day.
Sorry, only if you don't file.
Then your lordship may not order any personal appearance of only 25,000. If I will not, I will deposit 25,000. May not pass any order regarding.
All right, 25,000. List on.
Can it be posted at 2 p.m.? It is better.
All right. On 11th at 2 p.m. 11th May at 2 p.m.
11th May.
At 2
Lordship
p.m.
has fixed the date of filing of affidavit to
1st May.
First May. First. Obliged me.
Along with item number 52. madam. Item number 2.
None appears.
Item number 3.
May I please, my lord? My lord, here the Naib Sarpanch before your lordships ventilating the public grievances under Annexure 1, my lord, to stop the plying of heavy vehicles in their village road, my lord. That is pending before the collector, my lord. And the acknowledgement is at running page number 15, my lord. It has been given to the collector's grievance cell, my lord.
All right. The petitioner's representation, bracket Annexure 1 series, will be examined by the collector. Nayagat. And after notice to the petitioner,
Nayagat.
giving them here, petitioner and giving her a hearing. The reasoned order shall be passed not later than 1st May and communicated to the petitioner by 8th May. The court clarifies it as not expressed.
Obliged, my lord.
Item number 4.
May I please, my lords? Here, my lords, the challenge of this writ petition is an assessment order under 43. Because, my lord, the entire audit opinion has been followed in this matter, my lords. And the AG audit, whatever it has been dictated by the AG audit, has been verbatim reproduced with certain modifications. What has happened in this case, my lord, so far as Bhushan Steel is concerned, my lord, there was an oxygen plant, my lords. The petitioner purchased that oxygen plant with finance from Siray International, my lord, and leased it back to Siray, my lords. To Bhushan, my lords. So what has happened, my lord, this particular transfer by Bhushan, my lord, was not at all accepted by the assessing authority because of the audit did not accept it, my lords. What they said, my lord, is Bhushan is a manufacturer of steel. It is not a manufacturer of machinery, which is not the case with the petitioner, my lords. Bhushan, my lord, the plant was not moved out of Dhenkanal, the plant site. So that is also not a condition of the lease, my lords. And these various lease principles, which have been also decided by this Honorable Court, by your Lordships, my Lord, and even in 20th century finance,
No,
my
but
Lord.
why can't an appeal be filed?
Not here, your Lordship would appreciate the
Right.
entire, my Lord, your Lordship. I'll just place few paragraphs, my Lord. And what has happened, my Lord? This lease finance, which was denied by the assessing authority, subsequently in an arbitration proceeding after the Tatas have taken over, the Tatas, my Lord, they refused to pay this lease rentals. Arbitration proceeding was there, my Lord, at Delhi. Then I filed an additional affidavit. Your Lordship will kindly take up that, my Lords. In the arbitration affidavit in the Section 9 application, the Honorable Delhi High Court, my Lord, they recognized this lease principles, my Lords, and they recognize that there has been a leasing of machineries to the by the petitioner to the Bhushan, my Lords. And in an assessment in the income tax also, where the depreciation was claimed by the petitioner, they say, my Lord, that there has been a leasing of machineries to Bhushan. And these subsequent events, my Lord, were not even noticed because unfortunately these two subsequent events were not there at the time of assessment, my Lord. Why I was humbly praying, my Lord, that by no stretch of imagination, my Lord, this particular lease agreement can be brushed aside and said that this ITC claim that the petitioner has to be,
No,
my
but
Lord.
why can't the appellate authority examine that?
Lord, the appellate authority, my Lord, your Lordship would appreciate these two subsequent events were not there before the assessing authority, my Lord. No, your Lordship.
No, appellate authority, sir.
These, your Lordship.
You can always file an application for leading additional documents.
No, my Lord, your Lordship will kindly see the reasoning, my Lords. If your Lordships are satisfied with the reasoning, my Lords, I bow down, my Lords.
So why should we enter the merits? That's the whole point.
No, the whole aspect, my Lord, is a leasing of machinery, my Lord, can't be interpreted otherwise to deny my ITC claim,
You're
Lord.
not getting that. That's on merits.
But
You have an efficacious remedy. Why are you not availing?
Lord, I have a efficacious remedy, but your Lordship would appreciate, my Lord, the premise on which the particular petitioner, my Lord, and the assessing authority has advanced, my Lord, is not at all sustainable, my Lord.
Yes.
Lord, may I just humbly pray, my Lord, your Lordship will kindly turn to page 58, my Lords. If your Lordships are satisfied, my Lords.
Yeah, everybody, even appellate authority can.
Now, your Lordship will kindly turn to page 58, my Lords. The reasoning which he has been given, Lord, the brief facts of the case, my Lord. The dealer SSC Brace Iron and Steel Company deals in trading of machinery. The dealer has filed the returns on 33 of the Overt Act, disclosing purchase and sale of machinery, and is applied for Tran 1 of rupees so and so, and which has remained unadjusted for the period 36-2017. The dealer has availed an opening ITC of rupees so and so on 1/10/2015, which is brought forward ITC with quarter ending so and so after a regular set-off of output tax. The dealer has disclosed the purchase of goods of rupees so and so, including VAT. I've already paid VAT also on that from Bhushan Steel and Company via invoice number so and so dated 26/2/2015 and disclosed it as purchase from outside the state. That is not a fact, my Lord, in return for the quarter ending 2015. After the set-off of ITC against the regular output tax, the dealer has claimed opening ITC of rupees so and so on 1/10/2015. On examination of accounts, it is found the dealer has purchased equipments relating to production of oxygen, nitrogen, argon in gaseous and liquid form for a total cost of rupees so and so, including VAT of rupees so and so. On being asked, the dealer stated that the same has been used towards the transfer of right to use and leased to Bhushan Steel Limited. On verification of RC of Bhushan, it is found that the business activity of the said dealer is manufacturing of goods like slabs, billets, coils, and other than manufacturing and trading of machinery. No, this is completely irrelevant, my Lords. Machinery or equipments which have been sold to Brace Iron and Steel. It is clear that the machinery so sold are not manufactured by Bhushan and Steel. But the question does not arise, my Lords. My entire case, my Lord, then your Lordship would see the third reasoning. That as per the returns filed by the dealer SSC, Mrs. Brace Iron and Steel Private Limited, it appears that the dealer has disclosed to have effected purchase of capital goods in course of interstate trade and commerce and disclosed it in column number 18.2 of VAT returns in form VAT 201. The same transaction is also disclosed as interstate purchase in the annual return of for the year 14-15, for which ITC is not admissible as per section 28D of the OVAT Act. Further scrutiny of the documents like sale invoice issued by the seller clarify that the machinery equipment so sold have not been removed or uninstalled from the factory of the seller of Bhushan Steel Limited. Rather, it has been kept in the same place as it was, and it is only the paper transaction are made to the effect of purchase and sale, which is not a fact, my Lords. After the purchase made on paper transaction only, Mrs. Brace Iron and Steel Limited are given on leasing the same equipment to Bhushan Iron and Steel on transfer of right to use. In other hand, the instant dealer has claimed ITC for which the dealer is not eligible, my lord. I'll show, my lord, section 20 does not prohibit a sale. Transfer of right to use, my lord, is, your lordship knows, my lord, is a sale. And this particular sale, my lord, is not prohibited under section 20 of the OVAT Act. So it is construed that the dealer has claimed ITC against the purchase of old used capital goods, which has already been used by Bhushan Steel, which is prohibited under section 28C of the OVAT Act. Then the lordship would appreciate that in the written submission I've clearly and categorically stated in the written submission made by the dealer on 28/2/2019, the dealer has categorically quoted the various provisions of the Act and has stated that as per the agreement dated 22/2015, he has leased out the said machinery to Bhushan Steel Limited. He added that the instant company is a trader as per its RC and leased the machinery and equipment for transfer of right to use. Transfer of right to use is a sale as per definition of sale under the VAT Act. Hence, he claimed that he has rightly claimed ITC. He added to his explanation that though he disclosed the purchase as interstate purchases in VAT return, he disclosed it correctly in the annexures appended to the return, which is as per his books of accounts. Then he says, peruse the explanation submitted by the dealer, found that the explanation submitted by the dealer is not identical and applicable to the instant case for which the same is rejected. The assessing authorities of the opinion that the dealer is not eligible for ITC on the following grounds: that the dealer has mentioned in his VAT return for the quarter ending 2015 that he has purchased goods in the course of interstate trade and commerce for which no ITC is available to the dealer as per section 28D of the OVAT Act. He disclosed the same transaction as interstate purchases in the periodical return as well as the annual return for the year 14-15 in VAT 201A. It clarified that the dealer has already admitted the purchase as interstate purchases by disclosing it in the periodical return as well as in the annual return. A copy of the periodical return and annual return are downloaded from VATIS and placed on record for future transactions. Lord, I'll just stop here for the moment, my lords. Once he says that the goods are not moving out of the Bhushan's factory, my lord, the question of an interstate trade or commerce does not arise at all, my lords. Then your lordship would see, my lords, so far as paragraph 3, my lords, that in the instant case, the dealer claimed to have purchased goods from Bhushan Steel, but there is no movement of such goods. It's not necessary with great respect, my lords. Once the goods have been purchased by the purchasing dealer, the ownership of such goods must be transferred and lies with the purchasing dealer only. But in the instant case, the ownership of such goods are still with the selling dealer, namely Bhushan and Steel Limited, as the sale invoices raised by Bhushan and Steel Limited is with the condition that the goods are physically not removed. My humble contention, my lords, in Siray's international case, my lord, where boilers were given out on lease, my lord, the boilers were given out on as is where is basis, my lord. Even in 20th century finance, my lord, even though the context is otherwise, there was no movement of goods from the factory site, my lord. And this lease financing principles, my lord, have been completely given a go by, my lords. And he says there's an interstate sale, which is not a fact. And contrary to his own finding that the goods are not moved out of the factory gate of Bhushan, my lords. Then he says, my lord, Bhushan is a manufacturer of iron and steel, so he's not a manufacturer of machinery, so there can't be any sale to you and no transfer back, which is not relevant at all. Bhushan, my lord, uses this oxygen plant for production of steel. And this particular oxygen plant was purchased from Bhushan. And after that, it was a lease agreement to them. If your lordship would see, my lord, I have also annexed the lease agreement, my lord, which was there before the assessing authority, and he takes cognizance of the fact that the lease agreement was there, my lords.
Yes.
On the very same day when the plant was purchased, my lord, the lease agreement was entered into, my lord. If your lordship would kindly take up my additional affidavit for me.
Yes.
That's at page 10, my lords.
Yes.
At 28
Yes.
of the additional affidavit. Your lordship got it?
Yes.
This is, my lord, a lease agreement entered into and a registered lease agreement. If your lordship would see that as per the agreement at page 11, the lessee and lessors are hereby individual. Your lordship got it?
Yes, we have it.
Whereas the lessor is the owner in possession of equipment listed in the Schedule 1 here to equipments. The lessor is engaged in the business of leasing of assets on an opening lease basis. The lessee is engaged in the business of manufacturing steel and steel products at various facilities, including at its steel plant located in Meramundali, Odisha. For the purpose of carrying out its business, the lessee has approached the lessor for taking on lease the equipments on an operating lease basis. The lessor has considered the request of the lessee as above and agreed to lease the equipment to the lessee for carrying on its business as an operating lease basis, my lords. Now, this particular aspect, my lord, this particular lease agreement was, my lord, entered into on the very same day, that is 26th of February 2015.
Mr. Kare, still, you can argue all this with the appellate.
Your lordship would appreciate, my lord, I understand your lordship's mind, but your lordship would see, my lord, purposely, my lord, a lease agreement, my lord, is now being demolished and saying that you are not eligible, and a 13 crores or more demand with penalty, my lord, of equal amount is now being raised, my lords, for nothing, my lords.
All right.
And your lordship would appreciate the entire exercise, my lord. If your lordship would kindly see the assessing order, my lord, I'll not bother your lordship further, my lords. This was done completely at the behest of the AG, my lords. Your lordship would see, my lord, that your lordship would get it at page 60.
Yes.
Last two lines. Page 60, last two lines.
Yes.
In the instant dealer claimed opening ITC of rupees so and so as SGST credit by filing Tran 1 under the GST Act. AG Odisha, during verification of Tran 1 record, has given their opinion that SGST credit so availed by the dealer in Tran 1 is irregular. So, as per the above discussions, it is considered that the transaction made by Messrs. Brace Iron and Steel Limited with Bhushan Steel Limited is only a paper transaction in order to avoid tax liability, which is not the case, my lords. And if your lordship would for a moment, Lord, I've disturbed your lordship for quite some time. Only small, the Honorable Delhi High Court's order and arbitration. What has happened, my lord? After Bhushan was taken over by Tatas refused to pay the lease rentals. Arbitration proceeding was initiated, my lord, at Delhi. So, in the meantime, a Section 9 application was filed before the Honorable Delhi High Court, my lord. Your lordship may kindly turn to page 29 of my additional affidavit.
Yes. Annexure 3.
Annexure 3, my lords. There, my lords, they narrate the entire thing, my lords, that how this particular lease agreement has been effected with Bhushan, my lords. And there, my lords, they recognize the fact that there has been a lease agreement, and they recognize the fact that these are the various clauses, my lord, at page 33 and 34. And then, my lords, they have also said that this it was contested, and ultimately, my lord, at page 86. Page 86, my lord, they say that in view of the above, it is clear that rupees 18 crores being the contractual amount with effect from 1st April 2020, the said amount is prima facie payable to the respondent at least till the time the parties seek adjudication of dispute as per the contractual provisions. So it is directed that the respondent should pay the areas of lease rent. The lordship may kindly mark the rent after adjustment of the amount already paid to the lead lender bank, with applicable interest within 6 weeks from today. This payment shall be subject to the outcome of the prospective arbitration proceeding, so on and so forth, Lord. And this particular arbitration, Lord, was there between Tatas and your lordship may kindly turn to page 29, Lord. Between Brace in the Steel Private Limited and Tata Steel BSL Limited, Lord. There, my lord, and even in the sales tax, income tax, my lord, at page 87.
Yes.
Here, my lord, what has happened, my lord, depreciation claimed by the particular petitioner was denied, my lord. Then matter came up before the tribunal, my lord. The tribunal, my lord, took cognizance of the entire fact, my lord. And at page 87, my lords, they narrate the entire thing, my lords. If your lordship would see, my lords, paragraph 2.1 as an illustration. The SSC, your lordship,
yes,
in response to the same, submitted that it has purchased plant and machinery, that is oxygen plant from Bhushan Steel Limited, that is BSL for short, for an amount of so and so during the year under consideration. The SSC filed the agreement to transfer certain equipments executed by the SSC with BSL on 23/2/2015. From the said agreement, the assessing officer noted that the SSC intended to acquire certain equipments from BSL for rupees so and so. He noted that the SSC immediately transferred the asset on 23/2/2015 by agreement of sale, again leased back the same assets to the original owner, that is BSL, and in the process, the SSC claimed to have earned rupees so and so as accrued lease and the said assets during the year, my lords. So two authorities, my lord, and then your lordship may kindly turn to page 226, my lords. 2 to 6 of that brief, my lords.
Yes,
Paragraph 12.5.
yes,
We find, Your Lordship,
yes, yes.
we find that after considering various arguments made by both the sides, the Honorable Delhi High Court upheld the validity and veracity of the lease agreement dated 26/2/2015, and the terms stipulated therein, and held that the same is binding on both the parties. That means between Tatas, who are now the present owners, and the particular petitioner, my lords. The Honorable Delhi High Court has also held that the transaction is valid in spite of the fact that the respondent therein, that is Tata Steel BSL Limited, had also raised extra plea as raised, exact plea as raised by the assessing officer, that his transaction was not at arm's length and has thus led to the exaggerated amount being paid as lease rentals, and that were artificially fixed to meet a requirement of so and so. Although some of the paragraphs, that is not necessary, my lords. So the very fact that this is a lease between the particular petitioner and Bhushan, and subsequently with the Tatas, has also been recognized, my lord, by the Honorable Delhi High Court, by the income tax authorities, my lords. And unfortunately, our assessing authority, my lord, here in Orissa says, my lord, just because the goods have not moved out of the factory gate, just because Bhushan, my lord, is a manufacturer of steel, my lords, all these things has to be brushed aside, and your ITC has to be denied. I'll only humbly pray, my lord, subject to whatever your lordship says, my lord. These two documents, that is one dated 14/12/2020 of the Honorable Delhi High Court, and the judgment of the ITAT, which my instructions are, has not been challenged, my lord, before the Honorable, no appeals have been filed before the Honorable Delhi High Court, my lord, that is 3/8/2021, my lord, was not there before the assessing authority. Because the assessment, my lord, was passed on 15/3/2019. So these are subsequent events. And
You say, considering that there is an efficacious remedy of an appeal statutorily provided to the petitioner to enable it to challenge the impugned reassessment order dated 15th March 2019, passed by the Deputy Commissioner of Sales Tax, Denkanal Circle, Denkanal, under Section 43 of the OVAT Act for the period 1st October 2015 to 30th June 2017. From the court permits the court observes that the petitioner, if it so chooses, can avail the said statutory remedy of an appeal. If such appeal is filed not later than 1st May, 3rd April, accompanied by an application for condition of delay.
Can it be May, because these petitioners are in Delhi now?
Accompanied by application of condition of delay, explaining the delay on account of the pendency of the present petition. It will be considered with the appellate authority in accordance with law. The originals of the annexures be returned, subject to being substituted.
Can it be 2nd May, because 1st May may be a holiday, my lords, for that May day.
2nd May, correct.
Second. I'm sorry, my lords.
No, it's okay.
I'm unable to convince your lordships. I'm not. Can the appeal be targeted, my lords?
No, that you can do.
Grateful, man.
That statute has already targeted.
Sorry.
Statute has already targeted.
It's 4 years, man.
4 years.
4 years.
That's right.
Your lordship may grant me liberty to at least file an application for expeditious hearing.
Yeah, it will be open to the petitioner to request for expeditious disposal of the appeal. Correct.
Much appreciated. And to consider the subsequent events at least, my lords.
No, that of course you'll bring it to the notice, please.
Because they go by the audit report. That's all.
The petitioners forbid to urge all pleas raised in the present petition, including the ones raised in the additional affidavit, before the appellate authority.
Much grateful. Much grateful.
Item number 5.
Again, another unfortunate case, my lord, where the petitioner, my lord, she was, I'll just straight away take your lordships, my lord, to page 32, Annex 3, my lords. So
that case was an accident. What is this here?
This was, my lord, a gynecological problem, my lords.
I see.
And ultimately she was operated upon.
So again, delay, is it?
My lord, there's no delay, my lord. What has happened, my lord, an ex parte assessment, she could not file a show cause pursuant to, my lord's page.
You agree it can go back, sir?
Let it go back.
Prayer, my lord. Yes, my lord.
Let it go back, my lord.
Right. See, the challenge in the present petition is to an order dated 16th April 2022 of the Joint Commissioner, CT and GST, Baleshwar Circle, Baleshwar. under section 74 of the OGST Act 2017 for the tax period May 2020 to March 2021. Paragraph. A perusal of the impugned order reveals that it was passed ex parte without the participation of the
Statutory due was, no statutory due was filed, man. Deposited by the.
I was unable to file a show cause even.
All right. Unable to appear. So, in fact, the petitioner did not even file a reply to the show cause notice dated 21st February 2022, issued to her, preceding the above assessment order. Paragraph. In the petition, the petitioner has explained how she was suffering from a medical,
Gynecological problem.
gynecological problem for which she had to receive treatment. The medical certificate has also been enclosed. Paragraph. Having heard learned counsel of the parties, the court is of the view that the petitioner ought to be given one more chance to first reply to the show cause notice and then appear before the assessing authority for a fresh assessment order to be passed in accordance with law. Paragraph. Accordingly, while setting aside the impugned assessment order dated 16th April 2022 of the JCST, the court directs us under 1. The petitioner will first file a reply to the SCN dated
21/2/22.
21/2/2022 on or before 1st May 2023. The matter will thereafter be taken up by the JCST on 8th May 2023, and after hearing the petitioner, a fresh assessment order shall be passed within a period of 2 months thereafter. If agreed by such order, it will be open to the petitioner to seek appropriate remedies in accordance with law.
So can it be 2nd May?
2nd May. All right. 2nd.
Obligement.
Item number 6.
May I please, Your Lordship? Your Lordship, the limited grievance in this case was my refund application had been long pending and was not considered, despite filing it electronically as well as manually. My learned senior prayed for time last time to take instructions in the matter.
No, my lord, it has not been listed.
Your Lordship, in the meantime,
You took time for instructions. It was listed on 5th December.
Sorry, my lord.
Your Lordship, in the meantime, there has been certain developments that I will bring to Your Lordship's notice. The assessment order, pursuant to assessment order, my refund was flowing. That was 50 lakhs amount. So pending that, after that, I filed the refund application. Now the appeal order is passed in the meantime. And despite there not being any such ground, the appellate authority has dealt with this 50 lakhs refund application and has given certain findings on it. So based on that order, I have already challenged the same in second appeal.
So this is infructuous.
Well,
This is infructuous, but Your Lordship, until that second appeal is decided, let this refund application remain pending.
Why? You can always file a fresh one depending on the outcome of that.
As Your Lordship
It appears that during the pendency of the refund application, the order pursuant to which the said application was filed has been reversed in an appeal. And the SSC has filed a further appeal against that order, which is pending. Paragraph. In that view of the matter, the present petition seeking expeditious disposal of the refund application has become infructuous. It will be open to the petitioner, depending on the outcome of the further appeal filed by the petitioner, to further proceed in the matter in accordance with law.
and interest shall be considered at Lordship, interest aspect will be considered at the relevant point of time.
Obviously,
That is
obviously,
already
obviously.
there in the statute.
Statute itself. All right. The petition is accordingly disposed.
Obliged to go.
grateful, my lord.
Item number 7.
My lord, in item 7, my lord, against the order of passed under section 73 of the GST Act, lordships, the petitioner filed the appeal under section 107 by depositing the pre-deposit from electronic credit ledger. My appeal has been rejected, your lordships, on the ground of I have not paid and short paid the pre-deposit, your lordships. So when my lord, the circular dated 6th of July 2022 already has been held that Pre-deposit can be made from the electronic credit ledger. My appeal can be restored to your lordship. Puts original number, my lord.
No deposit has been made by
Yeah, because that
yes,
portal must-
credit ledger.
the short ground on which the petitioner is seeking the setting aside of the order dated
26th May 2022.
Yeah, 26 May 2022, passed by the Additional Commissioner of CT and GST, is that the system did not permit the petitioner to make the pre-deposit using the electronic credit ledger,
My lords.
bracket ECL. Paragraph, it is seen that by circular dated, it's annexed to the circular.
My lord, it is not annexed, my lords. Table 6, my lord.
By circular dated 6th July 2022, issued by the GST Policy Wing, the Central Board of Indirect Taxes and Customs, Department of Revenue, Ministry of Finance, Government of India. It has been clarified that payment of pre-deposit can be made by using the ECL. Paragraph. That view of matter, the impugned order dated 26 May 2022 is set aside. Petitioner will now, using the ECL, make payment of the pre-deposit for the purposes of the first appeal on or before 1st May.
My lord, already you make the pre-deposit, my lords. We have already made the pre-deposit, your lordships.
20%.
10%. This is the first appeal.
Yes.
All
Sorry.
right. The counsel, the petitioner points out that the petitioner has already made the pre-deposit using the ECL. That will now be accepted
My lords.
by the department. The appeal is now listed before the first appellate authority, that is the Additional Commissioner of CT and GST. On 2nd May 2023. The petitioner will appear on that day before the appellate authority along with the downloaded copy of this order. The appeal thereafter be disposed of afresh after hearing the petitioner and the department.
Obliged, my lord. My lord, the order of attachment can be withdrawn, my lord, under section 79.
Within a period of 3 months thereafter, the attachment order stands quashed.
Grateful, my lord.
My lord, I am applying for opposite party number 2.
All right.
Obliged.
Item number 8.
My lord, item number 8, your lordship, I am on behalf of Mr. Harichandra. He is not well and admitted to hospital. So
All right. State that counsel for the petitioner is unwell. 29th August.
Grateful, my lord. My lord, 8, 24 and 28, my lord.
Same.
Mr. Harichandra.
8, 24, 28. All right.
Grateful, my lord.
Item number 9.
Item 9 not present.
Not pressed, dismissed.
Item number 10.
My lord, in item number 10, the petitioner is challenging the demand dated 9/12/2021 issued by the Superintendent of Excise Jajpur, my lord, for the year 1920, alleging short-lifting of liquor for the year, my lord, 1920, which is at Annexure 1, page 11. Lordship, may kindly turn to page 11.
Yes.
My lord, in the same demand notice, they have referred to an excise department letter number 4494/EX dated 18/9/2021, which is at Annexure 2, my lord. The said letter of the government is also under challenge. So going in appeal before government or commissioner won't solve the purpose because the government letter is under challenge, my lord. The notice has to
Whether
issue.
this comment letter will be applicable to them or not, that is to be first decided because there is an appellate authority. Commissioner is the appellate. Let him go and say that, if the
Commissioner cannot stand over the government's letter, my lord.
Authority, he will decide.
My lord, Lord.
In his quasi-judicial capacity, he will decide.
Lordship,
not
It's only the applicability of the circular.
Lordship may permit me to approach the government.
No. Comment, you cannot surpass the commission. Commissioner is the appellate authority. Thereafter, government revision. Your
The
lordship has
validity
already
of government letter
shown
is
the
under
line.
challenge, my lord.
uh,
That validity of government letter is under challenge.
that is anybody. See, that applicability of that letter can be
Where they have
judged.
calculated the excise duty, that they are not permitted.
You are saying that you are not to be charged according
My
to
lord,
that.
my lord, on the
letter.
basis of the government letter only, they have issued me the demand.
Well, that is not written in.
That is
Annexure
written
1.
in the annexure 1 page 11, basing upon which they have issued me the demand.
And where have they said that?
My lord, referring to excise department letter number 4494 dated 18/9/2021.
My
In
lord,
the
that is
reference
the
only they
due-
have given.
That is the duty structure. Government has given in the
So that
policy a duty structure. How can the court interfere with the duty structure?
So that is the structure which they have on a basis
Structure
upon which
on each year excise policy followed by a duty structure.
that is not that, my lord, that is not as per policy.
What's your prayer clause? Let's see that.
My lord, my prayer is at page
What's the Niban notice?
annexure 1 and annexure 2 even.
Yeah, and the
Government's letter even.
that duty structure is applicable to throughout the state, and accordingly, all vendors are paying the duty amount.
My lord, under what basis they are calculating the duty?
Merely
The
because somebody
policy,
will
the
charge-
policy doesn't provide that, my lord. The policy which I have annexed, my lord, the duty structure is provided at page 82. The policy doesn't give that, my lord.
And this is also for 2019-20. We are now 22-23. This duty structure was for 19-20.
19-20.
Thereafter also revised.
Demand is also for the my lord, demand is also for 1920. Lordship may see page 11 at the cost of repetition, my lord.
No, you want to know the basis of calculation of this amounts, is it?
Yes.
My lord?
You want to know the basis on which they fix this excise duty at this.
My lord, the basis of calculation is to be as per policy, my lord. As per the excise policy which they have, which government has framed in the year 2019-20. That they have revised and issued a fresh duty structure, my lord, under annexure 2. That very letter is under challenge.
But it is not in accordance with the policy.
My lord, let them file counter then.
Where is the challenge?
It's better.
No,
They
no.
should.
In the grounds where have you challenged?
That is what I was also searching for. There is no such ground in the.
My lord, grounds are there, my lord. Ground number E, my lord.
E.
Page 4 of my writ petition. The order dated 8/9/21 referred to in the impugned demand has never been communicated to the petitioner. The impugned demand basing upon such uncommunicated letter is unsustainable in law, my lord.
No, that is a different thing.
My ground is even there, my lord.
This letter annexure 2
No,
is
again,
not
the impugned demand based on letter is unsustainable, not the letter itself. Where is the challenge to the letter?
and that letters is not to be communicated to all the vendors throughout the state. It is a government decision. It is available in the website also.
Lordship may kindly turn to page where they have aimed the duty, my lord. Lordship may kindly turn to page 82. In my lord, clause 3.1.1, they have given the excise, what is the basis to be calculated in the excise duty? Specific component into BL plus ad valorem. My lord, the space here they have written that the specific component is to be 35 rupees 35 per BL and ad valorem is to be 40%. My lord, may kindly turn to then page 12.
No, but you have to actually make out a case against that letter in the pleadings. In the pleadings, there's no ground challenging the letter. There's only a prayer clause.
My lord may then permit me to approach the government.
Counsel for the petitioner seeks leave, not government, excise commissioner. Counsel for the petitioner seeks leave to withdraw the present petition with liberty to file an appeal as provided under the Orissa excise rules.
252.
Rule 252 of the Orissa excise rules.
Read with section 6.
Read with section 6 of the Orissa Excise Act. Paragraph. If such appeal is filed not later than 17th April 2022, accompanied by an application of condition of delay, explained the delay on account of the pendency of the representation considered in accordance with law by the appellate authority. Court clarifies it is not expressed in the matter.
My lord, till then no coursive action.
No, there's no interim prayer here.
My lord, there is an interim application, my lord.
That's okay.
He will approach the commissioner for interim relief.
It will be open to the petitioner to approach the commissioner for interim relief. The court clarifies it is not expressed in the matter. Disposed of is withdrawn with liberties paid for in the above terms.
Item number 11.
Brief has been transferred.
Ah,
My name is deleted. Mr. Ekapatra.
the name of Mr. Arun Patra will be deleted. It is stated that brief has been transferred. Nobody else appears for the petitioner. Dismissed or non-prosecution.
Item number 12.
No instruction, my lord.
No instructions dismissed.
Item number 13.
I may plead the lordship, my lord.
Yes.
I'm on virtual mode, my lord.
Yes.
But say, look at the date chart, my lord. B. Page B, my lord.
Yes.
24/12/2000. The petition for lordship is assistant teacher. 24/12/2022. Mutual transfer application form submitted by the appellant and the respondent number 7. 38/6/2022. Verification of the mutual transfer application form made by BO and DO of the applicant. 27/12/2022. Mutual transfer order was approved. Let's see, look at my lord. Mutual transfer order was approved by the director, elementary education. Then my lord, 9/1/2022. Relief order of the appellant. Then my lord, on 10/1/2023, the appellant joined my lord. On 10/1/2023, cancellation of the mutual transfer order by DO Niagara, who is subordinate to the director. Lord, can you turn to page 11?
Mutual transfer means both people agree, correct?
Yes, my lord, page 11.
So the other person backed out, sir.
Therefore, I'm coming to page 11.
Ah,
That is the format, consent format for mutual transfer.
that's right. But after having given this initial consent, the person filed a representation withdrawing the consent.
Let's say, look at the undertaking.
So that's precisely the point. Nothing is etched in stone. If the person has sought.
My lord, logically turn to page 11.
Yes.
The undertaking. Annexure 1. The above information is true to the best of our knowledge and is based on our service records. We hereby give our consent for mutual transfer and will never deviate from our stand once it is approved. Logically, see the approval order at page annexure 3.
Yes.
So I say the estoppel applies.
So these are only mutual transfers. You can't elevate it to some level of promise or anything.
No, but here is a case where once you have given a consent and undertaking given, that will not.
Okay, sir. That's why I'm saying you can't elevate it to some contract. It's okay. But even a resignation letter, people say, permit me to withdraw my resignation. And there's a procedure for that also. It's like that.
Approval, madam. Once it is approved,
it's all right.
I can understand, madam. Before approval, resignation can be withdrawn.
Correct.
Undertaking can be
Anyway,
withdrawn.
this is only mutual transfer. You find out some other person who may be willing.
But these are the only consideration because he has undertaken. He has undertaken not to deviate.
Yes.
This is approved. I joined. But merely, and second point is the district inspector who cancelled. Look at who cancelled. Page 23, my lord. The district education officer, page 23, the district education officer has cancelled.
All right.
But wherein the director has passed the order, whether a subordinate officer can set aside the order of the higher authority.
So the basic point is that other person who had been willing to come over is now not willing to come over. It has to be a mutual exchange. You come from station A to station B, the person in station B comes to station A. That's the mutual transfer.
It's a cadre transfer from one district to another district.
Correct. Whatever I'm saying, now that other person will not budge from there. You will go from here, your seat will be vacant.
After my relief and join, my lord, and the undertaking was given that he will not deviate.
Anyway, this is not your first and last try. I'm sure you people keep trying. If it doesn't work this time, you'll try after a few months. Catch hold of some other employee.
This is my humble submission for Lordship.
Yes. All right. The challenge before the learned single judge was to an order whereby the earlier order permitting mutual transfer was recalled. Paragraph. As noted by the learned single judge in the impugned order, dated 17 January 2023, after the initial recommendation in favor of the mutual transfer was made by the authorities, the respondent number 7, is it? Filed a representation for cancellation of the mutual transfer order. So, in other words, respondent 7 was not willing to go through with the transfer, which would mean that respondent 7 would come in the place of the appellant and he would go to Nayagat in her place. Paragraph. As further correctly observed by the learned single judge, this being a case of mutual transfer, if one of the parties resiles, then the mutual transfer cannot go through. Paragraph was then argued that once an undertaking had been given in the application for mutual transfer, then it was binding on respondent 7, who should not be allowed to wriggle away from the consent already conveyed. Full stop. Paragraph. The consent to mutual transfer cannot be viewed as non-variable. Full stop. It cannot be elevated to a non-resiliable contract. Full stop. Further, the request for mutual transfer can be made even in future as long as another person is willing to come to the place where the appellant is stationed. Full stop. Consequently, the court is not inclined to interfere with the impugned order of the learned single judge. The writ appeal is dismissed.
Item number 14.
I pray for 4 weeks time to remove the defects.
4 weeks? Why? It's a 2019 matter, sir.
2 weeks, madam. So another aspect, my Lord's Justice Raman was the conducting.
No, all that is fine. The stamp reporting itself could not be made for 3 years. Why should one grant indulgence?
So 1 week, madam. So I will remove the defect as a last chance.
Defects have not been removed for over 3 years now. Counsel prays for a last chance. List on 3rd March before a bench of which Justice Raman is not a member.
God bless you.
Defects be removed in the meanwhile.
Item number 15.
Only dates to be changed. That is 13/1/2023. But they mentioned 2022.
Oh. Yeah, that order date be corrected as pointed out. All right.
Item number 16.
Wait, please, members. The writ of quo warrant to minutes. Opposite party number 4 had on the last occasion prayed for time to file counter affidavit. Probably senior advocate Mr. Santanu Sadangi was appearing for opposite party, private opposite party number 4. He had informed me on the last occasion the counter is ready. So I was only waiting.
Petitioner?
Petitioner, I am for the petitioner.
No. Counter is ready. You offer the petition. I'm not able to.
No. The opposite party number 4.
How? You're for opposite party number 4.
No, I am for the petitioner, my lords. I am for the petitioner. Your last order sheet, your lordship, the opposite
So
party
who's
number.
appearing there for opposite party number 4?
Mr. Santanu Sarangi, senior advocate.
Where is he?
Probably his name is not reflected in your lordship's cause list.
Or at the name of Dr. Santanu Sarangi, but he can't be senior counselor. His name can't be reflected. There must be an instructing counselor.
I have no idea. I received a call from Mr. Sarangi.
Oh, it's a first time listing, he says?
No. He's already been noticed. My lords, your lordship has issued notice on 4/6/2021. My learned friend Mr. Paddy has already filed a counter. I was waiting to file a rejoinder once the other.
No, which items, sir? Maybe we're making a mistake.
Item 16, my lords.
16889.
16889. 16889, 885.
No, it's what it is. 889, sir.
889.
Tushar Kanti Sahu.
My lords. Well, there's some confusion. Let it come next week. There's one order I'm holding where your lordship said issued notice 16885. I'm sorry, there's been some confusion.
Let it come. Coming up. That is also coming up today.
No, that's not coming.
No date.
Not today.
Name is same.
Name is same.
No date has been given in that.
No date. No date.
Okay. List on Sixth March, along with repetition civil 16885 of 2021. All right.
Item number 17.
17 minutes, petitioner permitted to withdraw matter.
All right. Disposal is withdrawn.
Item number 18.
I'm extremely sorry, Your Lordship. In fact, now I came across item 18 and 20. We've missed the list since our name is not reflecting.
Oh, the name of Ms. Kajal Sahu be reflected. Both in 18 and 20.
18 and 20, yes, Your Lordship.
All right. At her request.
And in the meantime, I'll remove the defects, Your Lordship.
It's a 2015 matter. Anyway, at her request, list on 14th March, defects be removed.
Obliged, Your Lordship.
Well, I'm sorry, that's item 16, my lord, fixing to 6th, my lord.
6th March.
Yes, obliged. I wait for the M's.
Item number 19.
19 it's 1 week time, further time to remove the defect. Because the date of receipt was wrongly mentioned in the
2015.
Yes, Lord. So that it was my mistake was it was filed WPC. Then it's converted to tax revision. Then I filed the IA for delay. Delay is not more than.
Let it be dismissed on delay, sir.
No, but the question is not the claim. It has been covered by your lordship order judgment, no? Because the form 4 which has been issued by the Steel Authority. And he has misutilized the said declaration form, but it
won't create a precedent. That's enough.
Not a huge amount.
Nothing. You say, what's the delay, sir?
Delay is not more.
The delay.
Delay may not 362 days. 362 days. And it's explained in the delay condition that it was filed WPC, then it's converted to tax revision. Dismiss for default, then I filed a revision. The delay has been explained, subject to lordship consideration.
This is a revision filed in 2015 with a delay of 362 days. In the last 8 years, no effort has been made to cure the defects, which are so basic, namely not mentioning the date of receipt of the impugned order and not filing an application for condonation of delay.
No, file is filed. It's filed.
It's not
just
there.
filed. IA number 37, Miscus 37. It's filed.
It's not listed.
2017 it is filed.
Okay. Then you give us a copy. We'll take it on board and deal with it now. It is stated that IA number Right in the beginning, you say IA number, that put that number, you say, it's there. Take that IA. It's okay, sir. Miss case number 37 of 2017. All right. This is an application for continuation of the delay of 362 days in filing the revision petition
Para 2 years last.
against the order dated 5th October 2010 of the Orissa Sales Tax Tribunal, bracket tribunal, in SA
It's number 1001. It is composite order, lordship. See,
1000 of 2006-7, 1001 of 2006-7,
yes,
and 1000, 1001, 1002 of 2006 for 7 for assessment years 2001, 2, 2, 3, and 3, 4 respectively. Paragraph. It is sought to be suggested that after receiving the impugned order of the tribunal, the petitioner erroneously filed a writ petition on 25th January 2011, which was dismissed for non-prosecution on 3rd November 2014. So thereafter, again waiting for 10 months, the tax revision was filed. Full stop. It is seen that in the above circumstances, the delay is attributable entirely to the petitioner's careless and casual attitude. The explanation that there was illness of the contracting counsel is not supported by any medical certificate. Full stop. Consequently, the court is not inclined to condone the delay in filing the revision case. Miss case number 37 of 2017 is accordingly dismissed. Full stop. Nevertheless, it is clarified that the questions of law sought to be urged in the present revision petition are kept open for consideration in some other appropriate case. Yes. The STREV is dismissed on the ground of delay.
Item 21.
Item 21, Your Lordship, similar matters are posted on 17th of April.
All right. List on 17th.
Obliged.
Item 22.
The certified copy has been filed in the other connected cases, batch of cases. Your Lordship, this matter may be taken up along with ST revision number 67, 68, 69, 70 of 2017.
When is it kept? When are those matters listed?
That has not been listed. All the matters, original certified copies have been filed in 67.
Those have not even come up for the first time.
Yes.
No, it has not even been listed once.
Earlier it was listed for removal of defect.
Okay. Oh.
6 cases.
Common order. So both these 71 and 72, you say list on March, defects be removed in the meanwhile.
Item number 25.
Along with STREV, correct.
ST revision number 67, 68, 69, 70 up to 2000.
All right, correct. Then total be 6. Right.
Item number 25.
May I please, Your Lordship?
Yes, please.
My Lord, I'm appearing for the petitioner virtually.
In 24? 25.
25.
24 is already adjourned. Yes, 25. Yes, please.
My Lord, this is a revision under the CST Act. There is a short delay of 7 days due to sickness of the concerned person, my Lord.
All right, delay condoned.
My Lord, kindly come to question of law at page 16. My lord, the first question of law is whether the learned tribunal is justified in upholding levy of interest under sub-rule 1 of Rule 8 of the Central Sales Tax Odisha Rules 1957 on tax determined as per the assessment order. And the second question of law is whether without a substantive provision in the CST Act 1956, interest can be demanded on tax determined as per the assessment order.
No, 1 minute. You've framed some different questions in page 9.
Page 16, my lord. Page 16.
What is in page 9?
It is before the tribunal, my lord.
My lord has already decided this question in favor of the department, my lord.
Ah, right. All right. I believe these questions are already decided in favor of the department. Is that right?
Question number 1, my lord. My lord.
Bureau pipes.
Yes, ma'am. Next page, para 3, my lord.
No, both are on penalty, sir.
No, my lord. The question number 1, first page, while admitting this revision petition on 10 July 2017, following questions framed for consideration by this court, whether in the facts and in the circumstances of the case, the Division Bench Odisha Sales Tax Tribunal is right in law to order for imposition of penalty under Rule 12(3)G of CST Odisha rules on short payment of admitted tax of such as being accessed is just and proper, more so when separate mechanism has been provided under Rule 8 and 8A of the CST Odisha rules for levy of interest and penalty respectively. And my lord has answered it. The next page, para 3. As far as question number 1
That's a different case, my lord.
in view of section 9(2)B of the Central Sales Tax Act 1956, CST Act, read with Rule 8 of the CST Odisha Rules 1957, the impugned order of the tribunal is set aside and the matter is remanded to the assessing of
it's remanded.
Yes, my lord. To calculate the interest part.
No, calculate interest or penalty.
Penalty has been deleted by my lords.
Oh.
Interest has been imposed.
Ah.
My lord, under Rule 8(1) of the CST Act, interest is payable if under Rule 8(1) of the CST rules, my lord, interest is payable if tax is not paid as per return and not as per the assessment order, my lord. In this case, interest is demanded on tax determined in the assessment order.
No, but isn't section 9(2)B covering it?
That is self-assessment, my lord.
Yeah, 9(2)B seems to cover it.
The language is same, my lord.
That's right. So the section itself provides now section 9(2)B.
My lord.
The language of the provision is same, my lord.
Correct.
Section 9(2). My lord, let the notice be issued.
Third time, you say, counsel for the department states at the outset that the questions sought to be urged by the petitioner are covered in favor of the department by the order dated 14/12/2022 of this court in STRAV 36 of 2017, bracket Duro Pipes Private Limited, State of Orissa. Paragraph. Counsel for the petitioner states that she will examine the order to and address the court on its applicability to the facts of the present case. At her request, list on. There's no urgency here. 5th September.
Item number 26.
Obliged, my lord.
May I please, your lordship. My lord, in this case, my lord, the department has come up with the appeal, my lord, challenging the order of the law and tribunal. There is delay of 5 days in preparing the appeal, my lord. Only 5 days delay for preparing the appeal, my lord. 5 days delay.
Delay condoned. All right.
There, lordship, kindly see page 12. That is the issues framed, whether in the facts and circumstances of the case, was the law tribunal illegally correct on holding that expenditure incurred for transfer of mining lease as capital, while the assessee amortized the expenditure as well as the expenses debited in PL account, whether in the facts and circumstances of the case, the law tribunal was legally correct in holding that the payment made towards transfer of mining lease is not treated as rent within the meaning of
notice returnable. August 31st.
Item 27.
27 is same, my lord.
Delay condone same.
Obliged.
Item number 29.
Lordship, kindly permit me to remove the defect in course of the day, my lords.
All right. List on. March, defects be removed in the middle.
Obligement.
Item number 30.
Party, my lord, not pressed.
Dismissed is not pressed.
Lordship, appearing for opposite party number 224.
All right.
Item number 32.
32, you'll see infractions.
Infractions disposed of.
The Lordship, appearing for opposite party number 125.
All right.
Item number 33.
33, let's see, already prayer has become infructuous because the attachment has been vacated.
Right.
But so far as demand notice is there, the legal heir may take steps on that. That may be. In this matter, joint account has been attached for the demand of the the deceased here. The department may proceed providing notice to the legal heir.
Sir, the prayer
Legal heir has not.
different.
My prayer has become infructuous as on date.
You say with the expiry of the petitioner,
Yes.
the prayer has become infructuous. The petition is disposed of. All right.
Item number 34.
It's 34, 35, 36. I'll remove the defects within a week, my lord.
All right. List on 14th March, defects be removed.
Item 37.
Item 37, my lord, I have just given the copy of the read petition, my lord. It has been defect. Defect was there. My lord, I have just now removed the defect.
All right. Tell us, what's the matter about?
My lord. Well, there is a discrepancy pointed out by filing the form GST on 9/3/2021. By way
This
of
must be covered. Oh, refund claim. Okay, transition TDS works contract. That's covered.
Magic's order.
Harish Chandra Maji. It will be dismissed in view of the judge. In view of the judgment in Harish Chandra Maji, the writ petition is dismissed. All right.
Lordship, I have appearing for opposite party number 3.
All right.
Item number 38.
May I please? Well, Lordship, in this matter, I'm being this. Well, Lordship, kindly have a glance at page 84, Your Lordship. My work order, the relevant page is 84.
You listed only a show cause notice.
Demand comes show cause notice while discharge certificates have already been issued in my favor. But 2017-18, Your Lordship, but
reply to this.
No, Your Lordship, already they have issued demand comes show cause notice for including 17-18 period, 17 to 2020. That comes show cause notice. Yes.
They are proposing this demand and you are to reply.
But Your Lordship, 17-18.
Point out in your reply that this is covered by the earlier order.
17-18 is already.
Just point out in that.
But yeah, let's say they have to the taking into account the subsequent circulars, they have issued this demand socus
Whatever, you
notice.
can reply
But
to that.
only for a, only kind of let's say Orida is a party that it has to answer this question because it is
All
going
that you need to say, you say in reply. Let them pass an order and after that you can come.
Similar order may be passed in this.
So you better copy.
But this is different from what my learned brother is saying because it is completely different.
Seen it.
Certificate itself here, let's say, will find that they have stated that it is not works contract.
We'll extend this. Here it says 1st March, we'll give you time to 3rd April to reply. 3rd April, the first paragraph, just change that a bit. The challenge in the present petition is to show cause notice dated 19/27 December 2022, issued by the Principal Commissioner, GST.
Additional Commissioner.
Additional Commissioner, GST and Central Excise, Bhubaneswar Commissioner. And then this, having heard Ms. Chaudhary, learned counsel. All right.
Item 39.
My lord, say I appear from opposite party number 3 to 5.
Item 13.
Sri Metallics.
Well, that is the IBC matter, my lords.
Ghanshyam Mishra.
Yes, my lords, lordship have kept it to 8th of May.
I'm going to constitute,
I'm lucky that
constitute the bench only for Sri Metallics matters.
My lords, your lordship delivered the first judgment in the High Court, this High Court, my lords, of this petitioner on 21st of June 2021. That was against the Irrigation Department.
Right.
And 40 crores was reduced to 4 lakhs somewhat by following Ghanshyam Mishra and that committee of creditors.
Now they're going to start preparing SLP.
No. SLP, they have not carried it.
No, now, after hearing you, they're going to do it.
Already barred by limitation.
There's nothing like that. All right. Same order.
Item number 40.
Item 40, my lord, this case, all the cases have been transferred to Delhi High Court, in fact.
It's already gone there.
Matter is pending before the Delhi High Court.
All right. These matters are already before the Delhi High Court. Consequently, no orders are required to be passed. All right.
In this case, I am happy.
The appeal is disposed of.
Opposite party.
Item number 41.
Even similar as yesterday, we are giving the orders of the Supreme Court. I am appearing for respondent 3, my lord, for government.
All right.
Still abide by. Ultimately, if we lose in Supreme Court, then we will comply, my lords, in terms of.
The challenge to the order dated 18/11/2021, and yesterday's order was what?
Yesterday, my lord said that it will come on September 13th, awaiting final orders.
This
yesterday's item 46 and 47 on the main list.
Correct.
Item 42.
Item 42, Your Lordship. 2 interim applications have been filed. One relating to condonation of delay in filing the writ appeal, that is a delay of 12 days, Your Lordship.
All right. Delay condoned.
And the other one is relating to an amendment, Your Lordship. Inadvertently, respondents have, the petitioners number 4 to 7 has been arrayed as respondents in the petition.
All right.
So amendment may be allowed, Your Lordship.
Okay, that 642/23 is allowed. The consolidated petition has been filed.
It will be filed, Your Lordship. Date may be set in the meanwhile.
Consolidated petition be filed by the next date. List on 27 June.
Yes.
Defects we cured in the meanwhile.
Defects have been removed already.
Some are pointed out.
One petition was noted in the noting. It was there for the amendment petition to be filed.
All right, whatever.
Copy has not been served, I think. Copy has been served.
Served.
Item 43.
It's not there.
Just check it out. I'll be serving a copy.
Item 43.
Let's turn to page 44. I given this.
Similar order.
Yes, on the next date, as in 3 to 24th April, I have given the text.
25th April, same order.
43 and 44, same.
43, 44, same. Okay.
Item 45.
45, not pressed.
Not pressed, discussed.
Item 46.
46.
At 46, the same day disposal.
It's not a same day disposal, my lords. Item number 46, my lords, your lordship have posted similar matters to 14th of March 2023, my lords. It's not a single disposal, my lords.
Yes, yes.
14th March. Not a 14th March.
Great. In the meantime, let them serve me a copy of the writ appeal, my lords.
In course of the day, sir.
Grateful, my lords.
Item 47.
My lord, 47, 20 days delay.
Delay condoned. All right.
My lord, in the instant case, Honorable Single Judge directed to the Cooperative Bank, Appellant Bank, to consider the regularization, outsourcing employee, respond number 1. My lord, similar matter pending before 1 AA 127 of 22. Honorable Court passed stay order.
Where is it? Where is that order?
My lord, I have not. I have called.
You're relying on it. You should give us a copy of the order.
My lord,
you'll pass it over, sir. Find out that order and bring.
Pass on.
Pass over.
Item 48.
48, my lord, same, no delay, but I have filed a condonation petition. This petition may be not pressed, no delay. In the same matter, my lord, outsourcing agency.
So you have to get that copy, sir. Pass
yes,
over.
yes, my lord.
Item 49.
May I please, your lordship? Item 49, 18-day delay. I have filed a petition for condonation of delay, as I found that the leave that has already been executed by the exam.
Come to the main matter.
Here, my lord. My lord, may I?
Yes, sir.
My lord, in that case, my lord, the petition challenging the order passed by the single judge, the ex parte, due to non-appearance of the learned counsel for the appellant having not been given opportunity to have it say, and the order passed by this honorable single judge, head by principle of natural justice, my lord.
Why? What natural justice?
My lord, if the appellant would have been giving, your lordship kindly have a glance, the order passed by this honorable court, page 35. Page 34. That non-appearance for the petitioner at the time of call, Mr. S. Jena, learned standing counsel for the school.
You show us why this, what has been written is incorrect.
My lord?
I think
what has been spelled out by single judge, where he has gone wrong, that was pointed.
My lord, on the basis of statement given by the state council that the petitioner has not the requisite qualification, so that he is not eligible to get that benefit. My sole prayer before your lordship, that your lordship kindly have a glance in annexure 1, that I have the requisite qualification for that purpose. That is the main point before your lordship. Your lordship kindly have a glance annexure 1, that is the graduation certificate and the BEd certificate. That is the main point, my lord. Your lordship, that is the only.
No, you said you are. No, requisite qualification for a trained graduate.
Trained graduate.
What is the requisite qualification for trained graduate post?
BD, BA,
Graduation with
graduation with BD.
Graduation with BEd, and in fact, his post was approved against the matricity. He was continuing in the post of matricity in the primary school. In the elementary school, there is no post of trained graduate teacher. So
And he wants to be appointed as trained graduate teacher.
He wants to be regularized as trained graduate.
And he has no BEd degree.
No BEd degree.
Yes, my lord. I am the BA degree, my lord. Your lord.
BEd, sir. Not BA.
BEd. My lord, your lordship kindly have a glance. Annexure 1. That is the BEd. Bachelor of Arts.
Then
and then BEd. Bachelor of Education. That is annexure 2.
But in that school, I think trained graduate sanction post is not there. That is what your case is.
His approval regularization was against the trained metric post. So he was never been promoted to the junior SS cadre. He was in the trained metric post, which is the LSS cadre, lower subordinate education service. There are 2 cadres in the department. One is a lower subordinate education department, and another is junior SS. So he was appointed against the post of low LSS. He was never been promoted to the junior SS. And there was no proceeding with regard to his absorption or appointment against the trained graduate teacher. Only because by virtue of subsequent qualifications, as my lord friend is submitting, because they have not solved the copy of the writ appeal memo, I am placing the material on the basis of the improved order.
Give him a copy, sir. Give him a copy.
Yes, my lord. In course of the day, I have
or a copy of the writ appeal memo be served on Mr. Mahapatra, counsel for the SME department. List on. 30th August.
My lord, pardon, 47, I have given order of this honorable court. 47.
Which date is it listed?
Yes, state filed the case.
Which date is it listed?
16 to, my lord, exactly, I can't say government.
Find out, sir. You're putting too much burden on us. Anyway, it's passed over. When it is called up, you find out. Yes.
Another date may be hit. Another.
You say at the request of counsel for the appellant, list on 14th March.
My lord, 2 cases.
Same.
47.
48.
Item number 50.
My lord, 1 week time may be allowed for the removal of defects.
The 2021 matter, sir.
Yes. Sir, only 1 week.
As a last opportunity, defects be removed by the next date. List on 2nd May.
My lord.
Item 51.
Matter number survives.
Infructuous disposed of. Right.
Placement. Item number 53.
Item 51, I am appearing to the opposite party, lords.
Item 53.
51.
53.
Item 53, my lord. May I please your lordship? This is a public interest litigation, my lord. Seeking for a direction to the state authorities to take care of the parks and playgrounds of Kotak city. Last time your lordship directed the council for CMC to file their counters.
Where is he?
Probably
Pass over.
Pass. Item 54.
Please, your lordships. Two queries were raised by this honorable court. Number one is whether the assessee has in fact paid tax as assessed by the sales tax officer Ballasore Circle. Whether the same amount has now been included in the assessment made by the sales tax officer Bargarh Circle. Mellors, the facts which has given rise to this query is like this. The petitioner who has a factory in the Bargarh at different depots all over the state and file an application before the commissioner for permitting him to file a consolidated return, which was allowed by the Annexer 1 at page 13, my lords. Then, my lords, he filed his return showing, including the turnover of Ballasore at Sambalpur, that was also included and accepted. Thereafter, my lords, the Ballasore Circle again assessed the same amount which was included in the turnover of Sambalpur, which was assessed by the Sambalpur. Thereafter, my lords, the petitioner carried an appeal, and the appellate authority at page 38 said that, admitted that the petitioner has already been given the permission, but he dismissed the appeal on the ground that the appellant, in his grounds of appeal, lords will be pleased to see page 38, internal page 7, has contended that an amount of rupees 45,43,044.80 has been included in the assessment order for the year 95-96, which has been done by the STO Sambalpur to Circle. As per his version, the amount of 45,43,044.80 is included in the total amount of rupees 58,14,59,068. But the appellant failed to produce any documentary evidence from the STO Sambalpur to Circles Bargarh that this amount of rupees 45,43,044, which relates to Ballasore Circle, has been included in the total amount as referred above, for which this forum is not in a position to accept the contention of the appellant in absence of any written document. Then, my lords, after dismissing this appeal, there were two second appeals filed before the sales tax tribunal. One was dismissed in limine. Then again, I approached this honorable court by the Annexer 9 at page 45. This honorable court again directed the tribunal to hear, and I filed the appeal with the supporting affidavit, which is Annexer 10, 11 at page 48 and 51. Written submission filed before the tribunal is page 12, Annexer 12, page 52 to 55. Then the tribunal also sustained the order of the first appellate authority as well as the assessing officer. Then I approached this honorable court. This honorable court raised the query, aforesaid query. Now an affidavit has been filed before this honorable court. I'll place the affidavit which has been filed. Lordship will be pleased to see their affidavit page 2, para 3. It is humbly submitted that as ascertained from the circle head, Ballasore Circle, the petitioner, Associated Cement Company, has not paid the demanded tax amount as has been assessed by the sales tax officer, Ballasore Circle, for the period 95-96 under the OST Act. Copy of the letter received from Ballasore Circle. Now they have enclosed. Now, second thing, para 4, humbly submitted that the permission by the to file consolidated return was issued by the Commission of Sales Tax Orissa by notification number so and so, dated 3/2/96. The assessment in the case of Associated Cement Company Limited, erstwhile it called for the period 95-96 under the OST Act, was passed by the STO Bargarh Circle erstwhile Sambalpur 2 circle on dated 26th of December 96, wherein the STO has accepted the consolidated revised return filed by the petitioner, which included the turnover of the Baleswar division. Lordship may kindly mark it. Copy of the assessment order, then he encloses. Then para 4. Also, this is also the submitted that the consolidated revised return.
So again in para 7, there's an admission.
Yes, para 7 is the admission.
All right. The affidavit filed with the department clearly indicates that the assessment order passed by the STO Baleshwar,
yes,
Baleshwar Circle on 1st March 1991, determining the turnover of the petitioner of the period 1995-96, was again sought to be brought to tax. No, again sought to be assessed and demanded by the subsequent assessment order passed by the STO Bargad Circle on 26/12/1996. Full stop. In view of the above admission, the impugned assessment order
Annexus 7 minors.
Yeah, bracket Annexus 7.
7 is the appellate authority's order. Baleswar is Annexus 6, page 29 minors. I am extremely sorry. I am extremely sorry.
In that view of the matter, the assessment order passed by the STO Baleshwar Circle. No, but what has to be set aside?
Set aside is the order of the tribunal, my lords. That is Annexus 13, page 56.
No. The question that you frame, just come to page 10.
Yes.
So we have to set aside the Baleshwar STO's order.
Yes. Baleshwar.
That's the matter, the order.
Against actually the Baleshwar Circle's demand, I went to first appellate authority as well as before the tribunal. Only Baleswar. Where he included the turnover of Bargad.
Not the other way around.
No. In fact, in the question of law, perhaps there was some consistency. Yes, my understanding is right. Baleswar has to go.
Baleswar has to go.
Oh.
And refund has to flow.
All right. For the above reasons, the impugned assessment order dated 1st March 1999 passed by the STO Baleshwar Circle and the corresponding order dated 24th March 2000 by the ACST Baleshwar and the order dated 30th September 2008 by the Orissa Sales Tax Tribunal in essay number 73/2000-2001 are hereby set aside. So it will be open to the petitioner to apply for refund.
If tax, because the instruction is there, no tax has been paid. If paid, he may apply.
No, you decide. Why you are so much panic about the refund?
Is directed for
in accordance with law. Yeah.
No. My lords have said that you have to apply. You cannot restrict me in applying.
All right. The question framed stands answered in favor of the SCC and against the department.
Yes.
Right.
Much obliged.
All right. So right in the beginning, you say, by the order dated 10/12/2010, the following question is framed for consideration. Reproduce that question, and then all of this. All right.
Item number 55.
Much obliged.
Make please. May I pray for a Passover, my lord? Pray for a Passover, my lord. 55.
Very well. Milots, I appear virtually, Milots, in this matter, Milots.
Right.
It is covered issue, Milots. CIRP period demands your lordships have passed order in this very petitioner's own case.
In fact, I have sent a photocopy of some of the judgments, my lord. I would only highlight one issue, my lord. Here, for the period under consideration, yes, it's a pre-CIRP period, no doubt, my lord. But at that point of time, the department was not required to file any claim before the RP. That was the recent judgment of the Honorable Apex Court, that the pre-amended provision. My lord, I have sent for photocopies of some of the judgments. My lord, may I just only pray for a passover, my lord. One passover.
All right, passover.
Very well.
Great. Item 56.
Madam, identical matters, my lordship has reserved the judgment regarding the entry tax matter imposition.
Orders reserved.
Publishment.
Item 57.
None appears dismissed.
Item 58.
Lord, I am in virtual mode, Your Lordship. Item 58, my lord, related to Harish Maji case, Your Lordship.
In view of the judgment in Harish Maji, this is dismissed. All right.
Item 59.
So item 59. Your Lordship may kindly see order dated 2/6/2021 passed by Lordship Milots. Your Lordship directed my friend to file counter and also me to respond to the counter. And the order was passed by Lordship since 2/6/21. No counter has been received, Lordship.
Last opportunity to file counter within 8 weeks, rejoined of the next date. Interim order to continue.
Published, my lord.
List on 14th September.
My lord.
Item number 60.
But in this case, the provisions of section 16(2)(c) of the GST and CGST Act is challenge, my lords. There's a batch of petitions there for Lordship, my lords. So what has happened? The supplier, my lords, to whom I have paid the tax, my lords, because he has availed credit and not deposited the tax, my lords. And your Lordship has also directed in this case to my friend to file counter and me to respond until today. That is order dated 2/9/21, my lords.
When is the batch coming up?
Because that date I don't remember because several cases are there.
All right.
Different dates are there.
Same order. Last opportunity to file a reply within 8 weeks, rejoined up to the next date. List on
interim also continues.
12th September.
May I pray your Lordship as a direction to my register to tag up all the matters together? To tag up all the matters together so that all can be heard.
You can find out. Yes, madam.
So interim order to continue.
There is no interim order, sir. It's subject to outcome. So that's
subject to outcome, yes.
That's what.
That order may kindly continue.
No, that is obvious, sir. We're supposed to continue that order.
My lord.
In item number 59 and 16, I am appearing for the opposite party number 1.
All right.
Particularly in these type of cases, my lords, we have paid tax, my lord, to the seller. They have enjoyed credit. They are not paying tax. And if we will assist your Lordship, because I was expressing my anxiety the other day, your Lordship also appreciated matter for the other bench. Your Lordship can think of somebody paying tax, it's not getting the benefit of ITC bills, and I have been now asked to pay once more by initiating another proceeding. And they are enjoying without making payment of tax. It's a very precarious situation, Lords. This should be taken up with a little bit urgency also, because the interest is affected. Manners.
All right.
Item 61.
Item 61. This matter, Lords, a question involved has already been answered by your Lordship in 2 of your Lordship judgments. Your Lordship have addressed the issue. And the issue is, Lords, because initially there was an assessment, I filed appeal, Lords. Because against the appeal order, Lords, state did not file in a further appeal to tribunal. Because as my Lords knows, section 678 of the Orissa Value Added Tax Act, if the state is aggrieved, they can file appeal to tribunal. If I am aggrieved, I can also move to tribunal. State did not choose to file appeal, Lords. And the issues which have been addressed in the first appeal, Lords, are again forming subject matter of sobert revision, Lords. And your Lordship, I have challenged the sobert revision order, and your Lordship have said there is a bar in the statute itself, 79(4)(b). My Lords may kindly see the judgment I have given to your Lordship, Lords.
But here no counter filed again.
No counter file, but this can be disclosed. The admitted position of fact. There is no controversy so far as facts and matters to record. These are all matters to record.
This is an appeal.
This is the appeal, Lords, OVTA. Your Lordship, if your Lordship permit me, I can only show the instances. Annexure 9 is the impugned order. You, my Lords, may kindly see for a while. Page 76.
Yes.
Page 76. Your Lordship will find 3 reasons are given with us in the so much revision proceeding at page 77. My Lordship, kindly see page 77. Upon scrutiny of the above mentioned first appeal order, it prima facie appears the following reasons to be erroneous for being prejudicial to the interpreter. 1. The input tax credit insert ITC is reversed as per section 29G of the OVA Act, which rule 11(1) is obeyed rules against sale of tax exempt goods, DLK, which comes to 62,42,122, whereas the first appellate authority allowed reversal of 22,94,784. Hence, there is less reversal of 39,47,338 resulting under assessment. This issue has been dealt in at page 68 of the appeal order, Milords. Page 68, 22,94,784. Page 68. Because I have reconciled this with your Lordship will find from the last 3-4 paragraphs at page 68. Thus, after reduction of ITC of rupees so and so under section 23D and a reversal of ITC of 22,94,785 on under rule 12 read with 11(1) of the OVA Act from creditable ITC of rupees so and so disclosed in return, total credit to ITC redetermined so and so. So this has been addressed by the first appeal authority. Second issue, my lords, irregular allowance of rupees 7,16,865 during the tax period so and so. Your Lordship will find from page 69, the very next page.
Right.
It is 7,16,865 is allowed. And the question is, Lords, this appellate order under section 70 appealable at the instance of the state Lords under section 79. Section 79 was not they did not choose to file appeal before the tribunal. So therefore, by not preferring appeal before the tribunal, they cannot
covered by that Sarala project. The issue has been answered.
Yes, both issues are.
So in the other case, the department has accepted that appeal order and has carried out. So that case would be a little different. Here, the department has not carried out the appeal order. Sarala project, the issue has been answered. Sarala project, paragraph 6.
Paragraph 6, yes.
All right. The present appeal questions are not related. 28 September 2021. Passed by the Commission of Sales Tax Odisha. By way of a suo motu revision under section 79 bracket 1 of the OVA Act 2004 for the period 1st October 2015 to 30th September 2016. Thereby setting aside an order dated 29 June 2018 of the Additional Commissioner of Sales Tax bracket appeal North Zone Sambalpur in first appeal case number AA-40 bracket B oblique 2018-19. Paragraph. The background facts. You say this writ appeal is already stood admitted by the order dated 19 January 2022. Paragraph. The following question is framed for consideration. Whether, despite the remedy of the of an appeal under section 78 of the OVA Act being available to the department against the order of the appellate authority in favor of the SSC, the commissioner could have exercised suo motu judicial power under section 79 bracket 1 of the OVA Act. Paragraph. The relevant facts as far as the present appeal is concerned is that challenging a reassessment order dated 20th March 2018, passed by the Deputy Collector of Sales Tax, Bargat Circle, Bargat. The appellant preferred an appeal before the
Page 65. Yes.
Yeah. Additional Commissioner of Sales Tax bracket appeal. North Zone, Sambalpur. Full stop. The said appeal came to be allowed by the order dated 25th April 2018. 29 June 2018. Full stop. As in terms of which it was held that the appellant had paid excess tax amounting to rupees 225,277. Full stop. It was directed to be refunded to the appellant. More than a year thereafter, nearly 2 years thereafter, the Commissioner of Sales Tax invoked suo motu revisional power under Section 79 bracket 1 of the OAT Act and issued a show cause notice dated 12th May 2020 to the appellant. It was alleged that there was less reversal of ITC amounting to rupees 39,47,338, resulting in underassessment of tax and irregular allowance of tax credit of 716,865. Full stop. Thereafter, the impugned order dated 28 September 2021 came to be passed by the Commissioner, determining the tax payable by the appellant to be 51,55,791, apart from penalty. Full stop. Paragraph. In nearly identical facts, this court has, by the order dated 22nd December 2022, in writ petition civil 5129 of 2016 bracket Messrs. Sarala Project Works Private Limited versus Additional Commissioner of Sales Tax, Cuttack, bracket, held as under para 6 of that order. In the present case, no counterpart has been filed by the department. No, that you take that off. In that view of the matter, the above question framed is answered in favor of the appellant and against the department. Full stop. The impugned order dated 28 September 2021 is hereby set aside. Full stop. The appeal is allowed in the above terms, no resistance.
Item 62.
May I please, Lordship? My Lord, I am in virtual. My Lord, the similar order passed by this Honorable Court in WPC number 3067 of 2023. The matter of the income tax 148 notice.
That is
order, my Lord,
covered by your Lordship's order. I have only one copy, my Lord. I am sorry.
All right, same order.
Obliged, my Lord.
Right.
Item number 63.
So in this case, my lords, the petitioner has challenged Miller's imposition of penalty under 270A of the Income Tax Act, Miller's. That is order by Annexure 14. Your Lordship have Miller's seen the other day while issuing notice, counter and result has been filed, Miller's. But what has happened in this case? Only on the ground that the petitioner has not submitted the balance documents, Miller's, 270A is invoked, Miller's. 270A, Miller's, if your Lordship, I am taking your Lordship's attention directly to the improved order, Miller's. My Lordship may kindly see, it starts from page 192, Miller's.
Yes.
So, during assessment proceeding, that's from third paragraph.
Yes.
It was noticed that the assessee trust had claimed capital expenses amounting to 38 crores or more as application in income under section 11(1)A of the IT Act 61. However, even after repeated queries made by notices 142(1) of the Act as well as so-called notice, assessee had failed to provide necessary documents to prove genuineness of the expenses claim of 11(1)A of the balance amount of 22 crores 92 so was denied as application of income in the absence of relevant supporting documents, and the same was made for the purpose of charitable activity was not proved. Now the assessment was completed 143.3 read with 144B with an assessed income of 2292 14,167. That is the same amount that was subject to levy of tax. Now next page you will also may kindly see. Section 270 says that 1. The assessing officer may, during the course of any proceeding under this act, direct that any person who has underreported his income shall be liable to pay a penalty in addition to tax, if any, on the underreported income. 2. Here 278(2)B is invoked. 2. A person shall be considered to have underreported income if B. The income assessed is greater than the maximum amount not chargeable tax where no return of income has been furnished. This is a case, return of income has been furnished. So therefore, on the face of it, 278(2)B is not at all applicable. Then, thereafter, so-called notice was issued. Now, your Lordship may kindly see, I am skipping that paragraph because he says that despite of the time granted, you didn't respond. However, it is seen that the e-filing module that the assessee has not preferred appeal against the assessment order. This is important. In this case, I have filed appeal, Milords, against the order of assessment, Milords, and during pendency of the Milords appeal before the statutory appellate authority, now the penalty under section 270A has been imposed, Milords. Now let us see the date, Milords. If your Lordship kindly turn to the index, Milords, the top page of the brief, Milords, your Lordship will find annexure 10 at serial number 11. Copy of the appeal in form 35 along with acknowledgement. This is dated 23/2022. That your Lordship will find at page 175. Page 175.
Yes.
Minus. This is filed. There is a e-acknowledgement receipt. Your Lordship will see at the top end right hand side, 20th March 2022. Whereas, because after filing of the appeal, this order imposing penalty under 270 as per annexure 14, your Lordship have seen, this is passed on 1/4/2022. Now, while saying that I have no appeal is filed, now kindly see, sir, the next paragraph. The onus is on the part of, I am reading from again back to 193 minutes. The onus is on the part of the assessee to prove that it has not concealed the particulars of income knowingly or unknowingly while furnishing return of income. The assessee has failed to discharge responsibility. By letter dated so and so, the assessee has stated that he has filed an appeal against the assessment order under section 143 dated 23/4/2021. The assessee has not filed appeal in prescribed time limit. Assessee has filed appeal. Here he mentioned the date, Milords. 20th March 2022. After more than 11 months of the assessment order, the appeal is defective. Assessee has suppressed the income to the tune of 22 crores so and so. Only because of the action taken by the department, the amount of 22 crores so and so has been taxed. I have therefore reason to believe that the assessee has concealed particulars of income worth rupees so and so. I consider this as a fit case for imposing penalty. Now let me take a pause here, Milords. That's one thing. So far as the condonation of delay is concerned, Certainly, it is not for the assessing officer to deal with that. And as a matter of fact, on the face of it, my lords knows, as per so motto, writ appeal civil order passed by the Honorable Apex Court, which have annexed in the writ petition itself by the annexure 17, means all irrespective of the statutory limitation period, Millers 90 days from the date of 1/3/2022 shall be calculated for the purpose of computational limitation. That's any irrespective of any limitation for any act, Millers. Millers 1/3/2022, Millers 90 days from that. If it is higher, otherwise 90 days from 1/3/2022, as per Supreme Court's order, Millers. I have annexed it. Here, appeal is filed on 23/2020 within 20 days. So it is well within time, as per the Apex Court's order, Millers. And binding on every year, Lordship is also following, Millers, always, Millers. So therefore, by saying this, the assessing officer should not have, Millers, traversed beyond his area and, Millers, giving some observation. So far as the appeal condemnation matter is concerned, it is left to domain of appellate authority, but he has said so, which is also not a fact. Appeal is within time, and during pendency of appeal, he should not have, Millers, imposed 270A.
Today,
This
what's
is
happened?
Millers,
That appeal is still pending.
Still pending. And still pending. Millers, what I am submitting, now there is a judgment, of course.
This order is also applicable, my lord.
That everybody.
This order is also applicable.
And so far as 22 crores is concerned, that also I am giving, Millers, your Lordship may kindly see what is the findings in the assessment. Just because your Lordship is dealing with penalty, your Lordship may kindly see order of assessment at serial number 5, page 159 for a while, my Lordship may kindly see. Then I will take your Lordship's written judgment. 159. The relevant page, my Lordship may kindly turn to, Millers. Page 160, serial number 4.
Yes.
Yes. So on perusal of ITR for 2018-19, noted that SSC Trust has claimed capital expenses of 38 crores so and so as an application of income. Then your Lordship will find there is a table, instrument and equipment 22 crore 14,160 not allowed. Only 15 crores are allowed, Millers. That is mentioned in the next page. And the reason is, here it is, even after repeated queries under 142 as well as so-called SSC submitted only part details, wherein sources of capital expenses of so-and-so is given for item 2 to 7. Then in respect of instrument equipment, SSC filed one bill 4 times and copy of the is not clear, which is order. 4 times one bill is there. Now, your Lordship may kindly see, subsequently has done. Now, my Lordship may kindly see page, that's 113 minutes. What I have given, what I have not given. This is, Millers, a computer-generated, Millers, information from the income tax portal, which confirms page 113, annexure 3, 113, 113, my lord.
Yes, yes.
Annexure 3.
Yes.
Confirmation on submission of e-assessment response. Millers, there are responses, these are confirmed. And what is the document I have filed and followed by e-proceeding response acknowledgement? Then your Lordship may kindly see 115 page. This is a tabular form which I have given. Total claim your Lordship have seen 22 crores. That will your Lordship will find from page 117. Yes. Total amount is 22 crores 92,000. But this consists of one substantial amount, that is 21 crores 49,63,200, which this Acharya Hariyar has paid to Odisha State Medical Corporation for procurement of machinery, because as per the direction of the government, I will show your Lordship communication. I have to procure all machinery equipment only through Odisha Medical Corporation Limited, which is a statutory corporation of the state of Odisha, Millers. And all of those, Millers, your Lordship may kindly see name of the asset, date of purchase, cost of asset, name of the supplier, Millers, process of, sources of payment, payment status, all details are given. And this is followed by, your Lordship may kindly see tax invoice. And at page 121, your Lordship may kindly see the letter of the Additional Secretary of Government to the Director Acharya Hariyar, transfer of funds for purchase of equipment, inviting reference to letter number so-and-so. I am directed that permission is accorded in favor of Director ARC to transfer 21.61 crore to A7 for procurement 20 number equipment instruments. This is a cancer research hospital and terminal patients come here, referral patients come here. Next page, your Lordship may kindly see page 122. With reference to subject matter, I have to say that 21 crore 49 lakh 63,200 has been transferred to OSMHCL from AHRCC towards State Cancer Institute grant on Ethe via UTR number so and so for purchase of the following equipments, measure heads. Each measure head will have several. I need not go to all that. So by virtue of this letter, I have paid the entire money to the OSMHCL for procurement of machineries. And for all other balance 1 crore some odd, this is followed by tax invoices, which I have given, uploaded. But because that was not legible because of technical glitches, and he discarded. That is the reason. Can this be an instance of under-reporting? It can at best be a case where I have given, not legible. It could have been reconsidered. But he says under-reporting. And your Lordship have seen the reason granted is 270A, 2B, where no returns are filed. It's a case of returns have been filed. Tax audit report has been submitted. Evidence has been given in the assessment proceeding. But somehow, because of technical glitches, it's not legible. That is how discarded, and this is no. These are all under-report. This cannot turned out under no question of under-reporting. It's a medical institute. Lordship have realized the other day if money will go because of charitable trust, this is attending only the terminal patients, cancer patients. So much of funds, so much of penalty. Your Lordship the other day directed interim stay of the entire amount. Now, para 6 of the counter they have filed. They have not also denied the documents which I have filed in course of assessment proceeding. They don't say no. So therefore, they don't also object as per counter the genuineness of the documents which are available with me, which I have submitted, which they have not considered.
Right.
It can go back for, because now the matter is pending with the appellate authority, and the judgment which I have given to Lordship, I have in this said case, it is said now that appeal is pending. That is the case of in the case of Karnataka High Court. The judgment says, that is that paragraph, last paragraph, because the appeal is pending, the Honorable Court directed that the 270 penalty shall be quashed. But if situation so warrants, subject to outcome of the appeal, then the authority may proceed. With that, so that is my humble submission.
Mr. Chimanka.
Yes, my lord. The appeal is filed. It is more than 11 months. Assessment order. The appeal is effective. SSC has suppressed the income of so and so only because of the action taken by the department of the amount of 22 crores 92 lakhs has been taxed. I have therefore reason to believe. Let the appeal be discharged, my lord. And is a 270 is filed up. He must file the appeal, which is appealable order.
No, the stage of 278 does not arise, sir.
So main assessment order may kindly be the appeal which has been filed may be disposed of by paying 20% tax amount.
Against that, another writ is pending for Lordship, and your Lordship has granted stimulus.
No, but then you have to pursue that appeal, no?
My lord, how? Yes.
That's what he's saying. He's saying whatever you have to do to pursue the appeal, you do that. The 278.
It's a faceless appeal now. So it's faceless appeal. If your Lordship direct, it can be expedited or targeted also. So I will appear for hearing because all the documents I have uploaded, everything is there. Only it can be targeted so that it can be disposed of. But as per this judgment, if your Lordship will at all concur with this, it says that at this stage, 278 doesn't survive.
No, here there's a stay granted.
My lord.
I will permit you to expedite that appeal.
Yes.
Only what I am submitting, lords, 278 can revive subject to the outcome of the appeal if the situation so warrants. That is what your Lordship said.
No, but 270 has already been disposed of here. So where's question of reviving?
No.
You mean they may institute a fresh 278?
Yes, exactly. They can. This is how your Lordship said it is to be quashed, and if situation so warrants, subject to outcome of the appeal merits, it can appropriate order can be passed.
All right. The challenge in the present writ petition is to an order dated 1st April 2022. Passed by the additional. We don't know which of them is it.
Sorry, my lord.
They've not struck off the appropriate. Passed by the National Faceless Assessment Center, New Delhi.
New Delhi.
Yeah. Oh.
Income tax officer and NFS.
So income tax officer, NFSC Delhi.
Where do you get that? Page?
195.
No, that's right. No, the actual impugned order, where does it start? Annex 18, right?
Annex 17, Manoj.
Annexure 7.
No.
Sorry.
14.
14 Milos. Impugned order is annexure 14.
That's what.
It starts from page
Land
190.
assessments is under section 270 capital A of the Income Tax Act 1961, levying a penalty of rupees 1624,58,324 for the assessment year 2018-19. Paragraph, it must be noted here that while directing notice to issue in the petition on 21st April 2022, it was directed that no coercive action will be taken against the petitioner pursuant to the aforementioned order. Paragraph. The case of the petitioner is that against the assessment order dated 23rd April 2021 of the assessing authority, assessing officer, bracket AO, making an addition of rupees 2292,14,167, comma, the petitioner filed an appeal on 20th March 2022, belatedly on account of the COVID-19 pandemic. It is stated that the said appeal still pending. Paragraph. In the assessment order, dated 23rd April 2021, the AO directed initiation of separate penalty proceeding under section 270 capital A of the Income Tax Act 1961, bracket Act. Full stop. Pursuant thereto, show cause notices were issued to the petitioner on 26 July 2021 and 8 October 2021. Full stop. A final show cause notice was issued on 21st February 2022. And the case was referred to the designated verification unit, bracket DVU, bracket, which then served notice on the petitioner. Full stop. Paragraph. By a letter dated 20th March 2022, the petitioner informed the appellate authority, the department, that it had prepared an appeal against the assessment order. Stop. Nevertheless, by order dated 1st April 2022, the AO proceeded to levy penalty equivalent to 200% of the tax allegedly evaded, thereby calculating penalty as rupees 1624,58,324. Paragraph. Mr. Jagabandhu Sahu, learned senior counsel, appearing for the petitioner, points out that in the impugned order dated 1st April 2022, the NFAC has observed that
(272B).
Yeah, that he's invoking section 270 capital A bracket 2 bracket small b, which reads as under. In the present case, it is wrongly noted that the SSC has not filed any return of income when in fact the SSC had filed its return. Stop. It is further wrongly noted that the SSC open quotation has not preferred appeal against the assessment order, unquote, which also is erroneous, since in fact the petitioner had filed the aforementioned appeal. Stop. With both the grounds on which the impugned order under section 270 capital A has been passed being non-existent, and that being an erroneous premise on which the NFAC is proceeded, the court has no hesitation in holding that the impugned order dated 1st April 2022 is unsustainable in law. Stop. It is accordingly set aside. Paragraph. Mr. Sahu points out that the appeal is still pending. Appeal against the original assessment order is still pending. So, depending on the outcome of the appeal, it may be open to the department to revive the proceedings under section 270 capital A of the Act. The writ petition is disposed of in the above terms.
Deeply obliged. Item 64. My lord, 64, I'll file a rejoinder to the counter file. My lords may grant me 2 weeks' time.
Rejoinder be filed for the next date. Interim order to continue. List on 31st August.
Item number 65.
My lord, item 65, I think, is the same as serial number 38. One copy, my lord, I may be pardoned.
My lord, this is the matter relating to the controversy whether export of a cargo is coming under the cargo handling services or port services. Basing on this, they have issued a show cause notice under annexure 1, my lord.
So this is that after the 10-year gap again.
Again 10 years.
Yesterday we passed that order. Yesterday we passed.
Yesterday.
What serial number?
And this is the merit of the matter.
71. All right.
My lord, 71.
It's a different petitioner or same petitioner?
No, different petition. Different petition. But as per their counter, in the last paragraph, they have stated that the similar matter is pending before the apex court matter.
Yes, ma'am.
That has already been disposed of in favor of the assessment.
Sure,
the decision I have already given, ma'am.
It is given.
Konkan Marine.
Konkan.
That may be indicated, ma'am.
That may be indicated.
That may be indicated only.
All right.
Because we have taken that ground.
Right.
Deeply obliged.
Both the petitions you put together. These two petitions are by the same petitioner and arise from a different set of similar set of facts and are accordingly being disposed of by this common judgment. Paragraph. In writ petition civil 23950 of 2017, the challenges were notice dated 23rd April 2007 and letter dated 30th October 2017. Issued by the
Only period of next period.
Superintendent Audit Commissionerate asking the petitioner to appear personally in connection with an earlier show cause notice bracket SCN issued by the commissioner on 23rd April 2007. So that show cause notice was in connection with the case of the department regarding non-payment of service tax for the appellant providing single ports single port steamer agent service and single ports clearing and forwarding service. I think, single ports port service and cargo handling service, right? Non-provision, not payment of tax for providing single ports port service. it appears that no action was taken pursuant to the above show cause notice issued on 23rd April 2007. Which was for the period 1st October 2005 to 31st March 2006. Stop. The petitioner therefore was under the impression that the department had dropped the proceedings. Paragraph. After a lapse of 10 years, the second impugn notice dated 30th October 2017 was issued to the petitioner by the department, asking him to appear for the hearing. Stop. The petitioner filed an application dated 9th November 2017 before the authority, expressing its inability to collect evidence after a lapse of such a long time. Full stop. Thereafter, the present petition was filed. Which came up for hearing before this court on 27 November 2017. Stop. At the subsequent hearing on 11th December 2017, an interim order was passed staying further proceedings pursuant to the above notices. Stop. That interim order is continued. Paragraph. Pursuant to the notice issued, a counter affidavit was filed by the department, where inter alia reference has been made
at para 22 of the counter.
To
last 4 line.
pendency of civil appeals filed by the department, being civil appeal number 1765 of 2009. Bracket Commissioner of Central Excise, Mangalore versus Messrs. Konkan Marine Agencies. Against an order of the Sestat holding in favor of the SSC. Full stop. Mr. Patnaik points out that the said appeal stands dismissed by the Supreme Court of India by the order dated 11th January 2023, a copy of which has been enclosed to the note submitted today to the court. Paragraph. On its part, the petitioner places reliance on another judgment of the tribunal of the Sestat, South Zonal Bench, Bangalore, in the case of Messrs. Aspinwall and Company Limited. Versus Commissioner of Central Excise, bracket MANU /CB /0326/2010. Answering a similar issue in favor of the SSC. Good stop. The SLP against the said order also stands dismissed. The civil appeal number 10763 of 2017 stands dismissed by the.
They're only adding one extra
Supreme
number.
Court of India on 11 January 2023. Paragraph. The net result is the orders of the Sestat answering the issue in favor of the petitioners has been upheld by the Supreme Court of India. Paragraph. Accordingly, the impugned notice dated 23rd April 2007 and the further letter dated 23rd April 30th October 2017 issued by the department to the petitioner are hereby quashed.
Next number is different period.
Period is
two cases
different.
is there. Same petitioner. Period is two different period. Second period.
The challenge in the writ petition civil 21602 of 2017.
Period is 16 set to 01.
Notice dated 18 October 2006. And the consequent letters dated 21/22 September 2017 and 6th October 2017, which is for the period
Sixteen
16/7/2001 to 30th September 2005. So stop for the aforementioned reasons. The said two notices are also hereby quashed. Paragraph. Both writ petitions are allowed in the above terms, no order systems.
My appearance may be recorded.
Item 66.
Item 66, my lord. Here demand has been issued by the collector. Appeal lies to the, my lord, commissioner.
All right. Counsel, the petitioner seeks leave to withdraw the present petition to liberty to challenge the impugned demand notice before the excise commissioner by way of an appeal. Such appeal is filed not later than 1st May 2023, accompanied by an application for condonation of delay. It shall be considered in accordance with law by the excise commissioner. The court, if it is accompanied by an application for interim leave, then till such time.
My lord, interim order is there. Can we continue?
But it's until such time the excise commissioner passes an order thereon. The interim order passed by this court on 27th August 2020 will continue. The court clarifies it has not expressed any view in the matter.
Apply.
67.
67, my lord, the lottery extension, similar matter has been fixed to 6 July, my lord.
6 July. List on 6 July.
Similar item 79.
79.
79 also.
Also 6 July. All right.
Item 68.
Your Lordship, in item 68 on behalf of Mr. Devasis Manda, I pray for 2 weeks time, Your Lordship, to file the rejoinder.
All right. Rejoinder to be filed for the next date.
Meanwhile, Your Lordship, interim order to continue.
Interim order to continue.
Obliged, Your Lordship.
List on 26 September.
Obliged, Your Lordship.
Item 69.
69, my lord, state has not filed counter. Still last occasion, your lordship directed to file counter.
Reply be filed within 8 weeks. Rejoinder for the next date.
My lord, just a minute, my lord. So far as these matters are concerned, the challenge, the impugned order is passed by the commissioner. No, not commissioner, my lord, by the government in division case. What is the annexure? Annexure 1, page 27.
All right.
Sorry.
As a last chance, reply be filed within 8 weeks. Rejoinder for the next date. Interim order to continue. List on.
My lord, counter, just now I am filing the counter. My lord, just now I am filing the counter in WPC 7463 of 2023. It is there.
I see. All right, right. Then take it off. You see, counsel for the government states that the counter being filed today in 7463 of 2022 is being adopted for all the remaining writ petitions and put all the petitions together. Rejoinder will be filed for the next date. Interim order to continue. List on 30th August.
30th August. Public.
Item note 70.
My lord, item 70, I'm appearing for the appellant.
Kind of a glance to the last order. Here, my lord directed, interim order, my lord directed to hand over the key of the particular premises which was allotted to him. Thereafter, my lord, I filed an affidavit that has been allotted to him. My lord, last date directed to take instruction to my learned friend whether that has been allotted or he has taken possession or not. This is the letter communicated to me that has been allotted to, and he has taken over possession.
My lord, yes, he has taken over possession. That is not in question. My lord, the writ appeal is a challenge to the order of the learned single judge, wherein, my lord, the learned single judge, by taking into account.
No, my lord, I am so far that interim application, compliance of the interim application, I am submitting.
Right.
So far the writ petition, I will be filing my lord's reply, my lord's
I
within 7 days.
stated that pursuant to the order dated 10th December 2021, passed by this court, possession of the office space in question. That is physical possession of the office space in question has already been handed over to the petitioner. Stop the written instructions of the Bhubaneswar Development Authority to Mr. Dayananda Mahapatra, learned standing counsel for the BDA, is placed on record. Paragraph. Mr. Mahapatra prays and is granted 8 weeks time to file reply.
My lord, this is a writ appeal.
Or to file an affidavit. All right. List on 27 September.
My lord, there's an interim order which was extended on last date.
That interim order was for the purpose of allotment of the house, my lord, that we have complied with.
Already over. Yes.
Item 71.
Here, there's an IA at flag B for deletion of the respondent number 9 as he had died. Other legal aids are on record.
All right. 147. So the reason states the application is allowed.
Respondent number 9 expired on 4/11/2000.
So I'm allowing this application, sir. It's getting deleted. All right. What's the delay?
Delay, my lords, is 227 days. On merits, we have a good case. Land dispute is involved. So my lord will consider. He couldn't file it in time.
But I will file objection to the my lord limitation.
All right. Then you say IA 471 of 2019.
Put a copy David limitation application.
Counsel appearing for the respondent's wishes to file a reply to this application. So reply will be filed within 4 weeks. Beyond a penny for the next date. List on 31st August.
But a IE of limitation may be short of.
We will.
Just August.
Supplementary list item number 72.
22, my lord, on behalf of Mr. Mahapatra, I pass over, my lord. I am for the appellant, my lord.
Okay. Item number 73.
Item 73, I will take fresh steps. The respondent number 1 has notice written unserved with. What's the delay?
10 days.
Within 2 weeks, I will try press correct address. Well, sent back, sir. Remitted to the appointing authority. Affording an opportunity. Why should we interfere with this? We need not interfere with this. Unnecessarily pending here for 3 years. You let me condone 11 days delay. Let me condone the delay. Addressee not found. Notice, but have you complied with the impugned order? There is no stay granted by this court. No stay. What has happened? Have you complied with the impugned order? I will take instruction. It might have been complied. I have no instruction. You pass it over. You take instruction. Pass it. Phone up and you take instruction.
Item 74.
Item 74, Madam Tripathi will argue this matter. He is out of station. I pray for day after tomorrow.
Who is the counsel appearing, sir?
Mr. BP Tripathi, man.
Last time you said alternative arrangement. Appellant wants to make. Last time the submission was counsel states appellant wants to make alternative arrangement. That's the answer submission made last time.
They have after the disposal of the writ petition, they have passed order. The opposite party has passed an order rejecting the direction prayer of the petitioner to regularize them. So it giving a fresh cause of action that it may be alternate.
Then it's infructuous then. Counsel for the appellant points out that pursuant to the impugned order, a fresh order has been passed, giving rise to a fresh cause of action. That way, in view of the matter, the writ appeal has been rendered infructuous and is disposed of as such.
Item 75.
So 25 on behalf of Mr. Das Mehra, I will respond or modification I file government or copy not sir 17023 I number. Also similar matter posted for 13 July other 2 matters
Who has filed this? IAS, sir?
I have filed an IAS for modification. That matter relating to the questioning of the transfer order by the Honorable Single Judge, Lordship can find it from page 30 of the writ appeal mail. And 3 matters are there. Your Lordship has already 2 matters. Your Lordship has fixed to 14th July. There is one WA number 412 of 2021.
No. What is this modification?
My sir. Modification petition on practice. Modification filing. Modification filing. Modification filing. It's not. That's filing. 75 is.
Which modification of order? Where is the IA? Which order you want modified?
Sorry, madam, that file is misplaced. That file, municipality file is misplaced. My state file is with me. Well, you'll ask me one password. Right.
The government has filed the IA from modification of order letter 16/11/2022, wherein the Honorable Court has directed them to give them joining either at Talcher or at Hindur, the transfer place. And in that situation, they have filed a modification saying that since there is no post at Hindur and they can appoint at anywhere in the state. That is the modification the government has filed.
So you are opposing or whom are you appearing for?
I am for the municipality lordship. I support the stand taken by the government.
I'm a respondent, my lord. A copy note, sir. Modification copy note, sir, my lord.
Now, what has happened in this case? May say transfer case, my lord. He has been transferred and relying though we have taken.
No. In your modification application, if you don't serve a copy.
Yes, I will serve, my lord.
You serve, you serve.
Yes, ma'am.
IA 170 council for the state which is filed. No, the present application has been filed by the state of Odisha seeking modification of the order dated
16/11/2022.
16/11/2022 passed by this court. Praying that they should be permitted to post the respondent at any other place except Indore municipality. Notice of the application be served on the contesting respondents. No, respondent number 1, sir. Council appearing for respondent number 1.
13 July.
In order to continue, list on. April 11th.
Other two matters have been added to 13th July.
13th July?
Yes, ma'am.
All right, list on 13th.
WA number 412 of 2021.
Along with 414 of 2021. 13th July.
412.
412. Along with 412.
412 of 2020-21.
21 and another 431 of 21.
And 431 of 21. All right.
Item 76.
Make this instruction. I beg to appear for the petitioner. On the last occasion on 30th September, my lords had asked a question about the maintainability of the writ petition and consequently the writ appeal. I'm raising two jurisdictional issues. One is the second respondent, claimant, is not a small enterprise within the meaning of the Micro, Small and Medium Enterprises Development Act 2006. And this is an aspect which is a jurisdictional fact which can be gone into the writ petition. And second is, the procedure prescribed under the Act in regard to conciliation and arbitration has not been followed, and that is governed by 3 judgments of the Supreme Court, where the Supreme Court has entertained appeals against the dismissal of writ petition, allowed the appeal, and said that the procedure followed is contrary to the mandatory provisions of the Act. Now, first on the question of whether it is the claimant is a small enterprise,
No, is it not an award, sir?
Yes.
What was challenged before the learned single judge was an award.
That's right.
Order number 3 can be
And that is challengeable under 34.
No, that's why. It's did the council have jurisdiction is the issue. Now, that is a matter.
Order number 3 specifically mentioned about it.
Yes, an award. My lords are right. It is an award. What is challenged before the single judge is an award, and that's what I am challenging. And that's a precise question whether Section 34 should be resorted to or not was the very objection raised in the matters which are considered by the Supreme Court under the same Act. And the court has taken the view these are jurisdictional facts, and therefore writ petitions are maintainable. The High Court had dismissed on the ground that Section 34 is the appropriate remedy and writ petition is not the appropriate remedy, and the Supreme Court has entertained the appeals and then allowed the appeals. I shall praise those judgments. But first, I want to satisfy my lords. The legal question that arises, which has not been considered by the council or by the learned single judge. Learned single judge proceeds on the basis that each unit is a separate unit. Whereas, in my respectful submission, if my lords will kindly have a look at the Act, there is no dispute that the second respondent is a company whose turnover is substantially more than even 10 crore, which is in respect of a medium enterprise. And therefore, it can't come under the small enterprise because small enterprise, the capital will have to be less than 5 crore. Kindly have a look at the definitions. Yes. Now,
No, the claimant is Gupta Power Infrastructure, right?
That's right.
Yes. Is Gupta Power not an MSME?
That's a question. In my respective information, it is not. It is not.
You mean Gupta Power is not?
It is not. Gupta Power is not. Because it is a bigger enterprise and therefore doesn't fall within the meaning of the either micro, small or medium enterprise. It is much bigger than even a medium enterprise. Please see the entire dispute arises under Chapter 5 of the Act. And who is a supplier? Supplier. Please see the liability is of the buyer to make the payment to the supplier. Where any supplier is Gupta Enterprises. Now, and the interest is governed by Section 16, 17, recovery of amount due. 18 is a reference to micro, small enterprises facilitation council. Now, please have a look at the 2 definitions which are relevant. 2M and 2N, and then Section 7.
Yes.
Supplier, because the dispute is between a supplier and a buyer.
Right.
The supplier means a micro or small enterprise which has filed a memorandum with the authority referred to in subsection 1 of section 8 and includes, we are not concerned with 1 and 2, we are concerned with 3, any company, cooperative society, trust or body by whatever name called, registered or constituted. Now, therefore, a company will be a supplier. Now, please also see definition 2M, small enterprise, means an enterprise classified as such under subclass 2 of class A or subclass 2 of class B of subsection 1 of section 7, because the second respondent claims to be a small enterprise. Now, kindly have a look at section 7. Classification of enterprises. Notwithstanding anything.
So the question is the investment in plant and machinery more than 25 lakh, but not more than 5 crores, correct?
That's right. That's right.
So your contention is their investment in plant and machinery exceeds 5 crores, according to you.
Yeah. each individual, they have a multiple unit. If each individual unit is separately taken, it may be less than 5 crore, and we are concerned with the unit in respect of which it is about 4 crore and odd, and therefore less than 5 crore. But the company, corporate entity, the enterprise we have the balance sheet. It is certainly more than that, and that is there is no dispute in regard to that. Therefore, the question is, under the Act, is each one of the unit to be separately considered, or is the company to be taken into account? If the company is taken into account, they are out of it. There is no dispute in factually. There can't be. We have all the material, factual material. I don't think that can be disputed. Therefore, question is, kindly see section 7. Notwithstanding anything contained in section 11B, the central government may, for the purpose of this act, by notification having regard to the provisions of section 4 and 5, classify any class or classes of enterprises, whether proprietorship, Hindu undivided family, association of persons, cooperative society, partnership firm, company, or undertaking. Now, if it is a unit which is part of a company, it is a company's capital investment that will have to be taken into account. Investment in plant and machinery. That is my submission, and therefore, if that is so, it's a jurisdictional issue. And unfortunately, both the council and the learned single judge have proceeded on the basis that each individual unit can be taken into account. This is one. Secondly, the procedure which is required to be followed, which is very clear under the Act, is that first they will resort to conciliation. The council will resort to conciliation. Section 18. 2. On receipt of a reference under subsection 1.
So why is a 34 petition not? Why will it be prejudicial to file a section 34?
The question of whether it is an enterprise, whether it is at all, whether this act governs it, is a matter, which is eminently to be gone into in a writ petition, because it's a jurisdictional fact.
But even in the section 34, you can raise it. If you look at Arbitration Act section 34, you can raise all this.
Section 18.
Section 34 on the question of jurisdiction of the council, with great respect. I don't think that's a...
I'm sure, Mr. Vaidyanathan, I'm sure you raised it before the council.
Yes, I did.
That would have been in the award, that must have been answered.
Just answer conciliation. No, in the award, it has not been an award. If I may praise the award, my lords will be shocked. Kindly have a look at the award. Ex specie, please see the award. There is absolutely no consideration of any of this. The award is at page 216. It's extraordinary. And this is precisely what has been commented upon by the Supreme Court. I shall place that in regard to what procedure is followed. Please see 216. This purpose should be the award. Please see. It sets out what happened, claim, counter, rejoinder, and then please see award. No consideration. The only reference page 220.
No, 1 minute. 1 minute. It refers to your counter, correct? That's page 218.
Yes. No hearing given. No hearing given.
No, sir. 1 minute. We'll go step by step. In that counter, there are 5 points.
Yes.
None of them say that this is not a medium enterprise or this is not a small enterprise.
That is my problem, because even though I have specifically raised it,
where is that?
Not even
where is your counter?
Yes, Miller. Kindly please see one of the objection, page 215. 215. And I will show the earlier counter also, 215.
No, this is addressed to your council.
This is our submission before on 27 June.
No, this is this is a letter to address to your advocate.
No, this is sent to the council.
Council, not the MSME council, sir.
No, MSME council. It's sent to MSME Council.
No. To Surat Roy, advocate. 215 is not a letter addressed to the MSME Council. Let us see the counter. This is anyway not a counter.
Yeah, very well, very well. Your Lordship may see the counter. Please see 223. No. I'm sorry, counter earlier. Counter before the council. Your Lordship will give me a minute. Page 99. Page 99. Para 5. Where I say in reply to the respondent states the claimant should be put to strict proof of the same by producing appropriate document to substantiate the compliance of section 7 and 8 of the Micro, Small and Medium Enterprises Development Act and also the complaint with requisite. Therefore, I raise an objection that they don't fall within that and they have to prove that. And specifically, this is an aspect which is argued before the learned single judge. Also, learned single judge proceeds on the basis that the companies is not to be taken into account on the basis that the notification issued has been withdrawn. Whereas throughout the understanding, and I shall place that. Now, therefore, and please see the award now, how it has gone about without any consideration, without any opportunity. And our problem is this: for a principal amount of 1 crore, according to us, it is about 97 lakhs. But let us proceed on the basis of what the council in its award says: 1 crore. Today, and it is in respect of.
Are you prepared to pay this 1 crore?
I will pay 1 crore with interest. 1 crore I will pay with interest, but not at the interest prescribed by them.
All right. Which is the interest you're willing to pay? Which is the interest you're willing to pay?
Your Lordship may fix any reasonable rate of interest. It's 9% interest.
Let him. You put it to your client. He's prepared to pay 1 crore with 9%.
Because they have to deposit anyway. If they file an appeal, also they have to deposit.
Anyway, so they're prepared to pay you directly, sir. No need to deposit. They're prepared to pay you 1 crore with 9%.
From the dates on which it became due from 2013 to 2023, 10 years, whatever is.
All right. Should I record it or?
Your Lordship may record it.
All right. Mr. Vaidyanathan, Learned Senior Counsel for the appellant, without prejudice to the rights and contentions of the appellant, makes on instructions states that the appellant is willing to pay the respondent number 2.
Yes.
That's right.
A sum of rupees 1 crore together with simple interest at 9% per annum for the period during which the amount was due up to the date of payment. Stop. Mr. S.P. Mishra and Senior Counsel appearing for the respondent 2 seek some time to seek instructions on the above statement. List on 1 month?
2 weeks after.
2 weeks. All right. 21st March?
Yes,
21st March, sir.
Very well. Great. Great.
All right.
Supplementary list item 77.
May I submit? Almost my senior have argued that matter. I'm also in the similar line, but in a bit different manner. What happened in this case? The respondent was the custom miller under the Markfed. Markfed is a government of Odisha society. What he has to do, he has to procure paddy from outside as per our instruction, then to convert it to rice, then CMR rice is to be supplied. There are a lot of defalcation. It was found on inquiry. It was found that no stocks are available with them. That is what vigilance proceeding and all these things are going on. So they wanted to raise a claim that yes, I will be entitled to that. We denied it on the ground that the provisions would be complied with, which cannot be given. Thereafter, we also raised another counterclaim that is a different contest altogether. Now he has gone to MSME court at a much later stage. During MSME stage, conciliation went on. Well, kindly have a glance to Annexure 4 to the read petition. That will clarify the situation. Annexure 4 to the read petition. Last portion. what the MSME authority did is, they proceeded on conciliation. And conciliation failed and immediately passed an hour without following the arbitration and conciliation process, as has been specified under section 18(2) of the Act. May I place now in this context 18(2). May I place it, madam? Now the law is well settled by Honorable Supreme Court. On receipt of the reference of session, this council shall either itself conduct conciliation in the matter or seek the assistance of any institution or center providing alternative dispute resolution services by making a reference to such an institution or center for conducting conciliation, and the provision of section 65 to 81 of the Arbitration and Conciliation Act shall apply to such a dispute, and as if the conciliation was initiated under part 3 of this Act. So while going for a conciliation, they have to follow the provisions of the Arbitration and Conciliation Act.
You're the claimant, is it? You're the claimant.
No, I am the respondent.
I am the claimant.
I am the respondent. My humble contention is, then kind of a glass to...
No, you say the MSME Act itself does not apply.
No. I say that MSME Act does not apply. That I have taken stand. Now fact remains what MSME did is, let us consider that yes, it does not apply. It applies for considering for the sake of argument. Then what the conciliation authority did is, they proceeded with the conciliation. Then conciliation failed.
The single judge has sent it back to the MSME.
That my learned senior brother has got it stayed in the High Court, Honorable High Court, proceeded in the execution with attachment of property and auction. Now recently, I filed another 2 petitions. Probably this is being misinterpreted. That conciliation authority already
said, come and appeal against what?
We have not. I have come.
I have come. Respond. That's why when you start,
I find a miscase, my lord.
The whole problem, sir. You start arguing that
my interim application, I mentioned it. I have but my interim.
Lordship, may I submit fast, Lordship? I am for the appellant here.
Claimant.
The Lordship. Claimant, and in this writ appeal, I am the appellant. And the only question of law that is to be decided in this writ appeal, whether the section 19 has been complied while admitting any application that challenged the award passed under the MSMED Act. Rightly, admittedly, the section 19, which is mandatory, the supplier has to deposit 75% of the award while challenging any award passed under MSMED Act. That has also made the law of the land. Lordship, I am submitting to recent decision of Honorable Apex Court.
Like a pre-deposit.
Lordship, only that is to be decided by this writ appeal. In this writ appeal.
What is your claim? What is the amount of claim?
Amount of claim is 30 lakhs principal with interest of 22 lakhs on whatever.
No. So he has to deposit 75% of 30 lakhs alone or 30 lakhs?
No, 30 lakhs alone.
Alone?
30 lakhs alone, not
interest. He has to simply deposit it.
Simply
it will not be paid to you.
No. Simply deposit and it may be disbursed in my favor.
After the award?
Yes.
So if a single judge had ordered the pre-deposit, you do not mind going back to the MSME?
No. I just, the law is to be followed, Lordship.
All right.
So once the application, that is also the wrong forum they have opted. That is the section 34. They have to go for any challenging the award. But they have, anyway, I don't mind that. But they have to...
As you're prepared, why don't you... It's not going to go to him. You make the 75% as a deposit, go for section 34.
May I submit here? That exactly, that is the point. What is my point, my lords? I'm referring to the judgment to point out.
Lordship, at this point.
Just a minute. My lords, may I humbly submit? What happened in this case? Conciliation proceeded, failed, then arbitration. Arbitration opened. But in view of this, that arbitration proceeding was not concluded and immediately an award without determining award was passed. That award is nullity in view of the Supreme Court decision. The award is a nullity. That is what Honorable Single Judge remanded the matter for adjudication for the award. There is no decree, that no award existing in the eye of law. There they have taken time, filed this petition, got an interim order of stay of the judgment of the Honorable Single Bench, now insisting my lord's execution to proceed and attachment and all these things. Well, I am submitting this judgment, my lords, kind of because that Honorable Supreme Court made it clear it is a nullity. It cannot be. If it conciliation
Let me finish first respect to my learned.
34 comes, my lords, if that hour after conciliation, there would be an arbitration, thereafter there would be an award, then I am bound to follow my lords 34. There is no contingency, then we have to deposit the amount. Here in this case, my lord, there is no award at all. That award would be passed after arbitration process followed.
All right, let's hear.
That might kind of a class to that.
No, but let's hear.
Lordship, kindly come to my decision that is submitted.
No, let's get to the facts of your case first. You come to the decision later.
Fact of the case is that I have challenged the learned single judge order dated 8/2/2021 that was passed in a writ petition challenging the award of passed by the MSCFC Council under MSMED Act on 30/12/2020. So admittedly, that is a final award passed by the MSCFC Council, and the right forum is Section 34 of the Arbitration and Conciliation Act. And another thing, Section 19 of the MSME Act, Lordship may kindly come to Section 19 of the Act.
You're not placing the facts correctly, sir.
Lordship, award has been challenged in a writ petition.
Before the award, what are the facts?
Yes, Lordship. Lordship, the present DHR is a rice mill owner. So the present JDR, they are the government agency. They are engaged in the supply of the paddy to the rice miller, and in return, rice miller just supply the custom rice to FCI, Food Corporation of India. That is the business. So in the business, we supplied some custom rice, but the payment was delayed. That's why we are coming under the micro enterprise sector. So we preferred this claim before the MSMD Council. That is under Section 15, 16, and 17 of the Act. So Council decided this case, and the award was made in.
No, there was a conciliation, sir. Why are you skipping facts?
Conciliation has been made.
I have to remind you, we are hearing your case, we are asking you to tell facts. We are telling you the facts.
Conciliation, several occasions, conciliation was made, and after that award was passed.
Not so simple, sir. When was conciliation held? Which date was conciliation held?
That's why I'm straight away coming to the point of law. That's why it's an appeal. That's why I'm not.
The most crucial fact you want to gloss over. Same point. Yeah. See that.
my file, Lordship. So Lordship may call it tomorrow so that just award I am the missing.
Prepare a list of dates.
Lordship.
Just for your information, just come to page 121 of the writ petition. You have the writ petition? No.
No. I am the writ appeal.
Do you have writ petition?
Yes.
Copy of the writ petition?
Yes, copy.
Sometimes I feel that I'm not speaking English. Every time my learned brother speaks, all of you correctly answer. When I speak, nobody understands. I have to go back to the English class and learn English now all over again.
Lordship, I may be allowed to come with a date chart so that it will be.
That's what I asked you to do.
Please take up.
Somewhere, my lord, I have misplaced all the.
Oh, you don't have that.
Lordship.
Tell it.
All right. Counsel for the appellant seeks time to prepare a list of dates. Just put this IA. Which is your IA?
My IA
82.
IA number
82 of 2023. So you say in IA 82 of 2023, notice, he accepts notice. It is directed till the next day. There shall be a stay of execution case number 26 of 21 in the court of the learned Civil Judge Senior Division, Commercial Court, Bhubaneswar.
Yes.
Right. List on. Fourth July.
Lordship, kindly fix it some dates earlier.
It's all right.
July is very late and it's a micro industry. Lordship may kindly.
When was this case listed last?
Last listed on.
Many times. Court number 3.
Lordship, July is 5 or 6 months. Lordship may keep it in May. Lordship may.
All right.
Item 78.
None appears to the appellant.
My lord, I am appealing. Yes, Mr.
You're for the opposite party. Right. Mr. Chimanka for the opposite party. All right.
Item number 80. Item 80.
Item 80, Millers. The last occasion reply, they wanted to file a reply. If they're not filing a reply, your lordship may keep this matter any day for hearing, Millers.
STA sales tax review. We will not file in reply.
Sales tax revision.
No.
Your lordship may have this matter any day for hearing.
All right. At the request of counsel, the petitioner. List on 4th July.
Very well. Great news.
Pastor matter.
There was an interim order in this.
No, there is no interim order.
Yes, Millers. On.
Yes.
Very well. Great.
Supplemental list passed over matter item number 53.
53, my lord, this is a public interest litigation. Last time, your lordship directed to counsel for the CMC to file the counter.
Debashish Naik was there. He has instructed me. I am appearing on his behalf. Whereas the affidavit has not been filed. He's seeking some time to file affidavit, and he has asked that if the Deputy Commissioner CMC, who's in charge of parks and plantation, may be directed to file the affidavit, then
Deputy Commissioner Mr. Naik states that the Deputy Commissioner CMC needs some more time to file an affidavit. As a last chance, affidavit be filed within 4 weeks, rejoined up for the next date. List on 4th July.
Right. Grateful. Passed on to item 55.
Notes 55. These matters notes relate to demands that have arisen prior to CIRP. Subsequently, Milot's resolution process has been completed. Resolution plan has been approved. I have given a chart for your lordship's.
You were to take instruction.
Yes, Lord. Lord, there is
In
no
fact-
dispute that these are all pre-CRP dues. Lord, my humble submission is that during this period, this is a pre-2017. During those period, the statutory authorities, they were not required to file any claim before the RP. So the RP ought to have taken it from the accounts because these are sales tax dues and reflected in their audited accounts.
Oh no, you have to file a claim, sir. Once a thing goes into CIRP, you have to file a claim.
May I just rely on one judgment?
Rainbow.
Yes.
Rainbow. That says that delay can be condoned. But
No, my lord,
doesn't
kindly see para 23.
No, after Ghanshyam Mishra, there's no question, sir.
My lord, Ghanshyam Mishra has been considered in this. My lord, may kindly turn to paragraph 22.
I think.
No. Are you now? Because once the CRP is over, where's the question?
My lord, it's over. We have not challenged that plan also. My only contention is that, my lord, hereby, what he is saying that all these statutory dues have extinguished. And my lord is questioning these orders. My difficulty is that in the plan itself, he is not coming up whether any provisioning has been made for the statutory dues or not. Now, if it is quashed today, if some provisioning is made in the plan for the statutory dues, now following this judgment, some of the honorable high courts have said in this kind of matters, let him file an affidavit. What is the treatment given to the statutory dues? So if now today it is quashed and in the plan some accounting has been made, then we will be nowhere, my lord. We cannot recover that amount as per the plan also.
Why don't you examine the plan?
On a plan,
Lords, may I assist, Milords? Your lordship will see flag B, the IA that I have filed at page 62. Identical cases came up before your lordships in this petitioner's own case. Your lordships have already passed orders.
There, your lordship have highlighted.
Just clarify. GST, VAT, sorry, Milords, CST, VAT, ET demands.
Annexure D.
Yeah.
Annexure D.
Annexure D.
And here also it's VAT, is it?
Yes, my lords. VAT, ET,
Just for
CST.
different years. That's
There's
it.
just different years.
There that this judgment has not been brought out. I only just
No, we don't have to review this order.
No, my lord, let it be extinguished. My contention is that in terms of the resolution plan, that may be indicated. Because suppose tomorrow in the resolution plan, some accounting have been made for the tax for the statutory dues. And today, if the demand order goes, well, tomorrow we cannot recover as per the plan also.
That's true.
So, my lord may only indicate
supposed to extinguish all past debts. That's the whole idea of a CIRP.
Well, extinguishment subject to the plan. In the plan also, provisioning is made for the statutory dues, my lord. So today, let him say no plan has no accounting for these statutory dues has not been accounted for and zero has been awarded. We will have no difficulty, my lord.
What is your answer to that?
My lords, my humble submission is number one, my lords. Insofar as resolution plan is concerned, whatever is there in the resolution plan that has to be carried out by me, or else I will.
So why don't you place the resolution plan then?
Yes.
Yes,
that
my lords,
would clarify, my lord.
I will file that resolution plan again. But my lords, we'll see. I have quoted the relevant portion of the resolution plan at page 4. How much is to be paid?
Well, quoting is only to the extent of extinguishment. I don't have any difficulty. Rest of my claims will be extinguished. I don't have any difficulty.
Para 7, my lords. Subject to para 4.4 below, the resolution plan shall identify creditors who shall be paid.
Where are you reading?
Exactly.
Page 4 of the IA, my lords, flag B.
Yes.
Subject to para 4.4 below, the resolution applicant shall identify creditors who shall be paid an amount not exceeding INR 30 crores as OC discharge amount. OC is operational creditors. So all operational creditors will be paid 30 crores. That is what the plan envisages. So whoever are the operational creditors, they will be paid in pro rata format, pro rata basis on this 30 crores. They will be paid 30 crores in total. Whoever are the operational creditors. Now, Millards, secondly, Millards, whatever claims are filed, these claims are taken care of in this 30 crores. So there was a total of 304 crores which has been settled with this 30 crores. That is what the resolution plan encompasses.
So if you don't file a claim, you won't get anything.
Yes.
No.
And that is the judgment of Ghanshyam Mishra.
Correct.
Post approval of resolution plan, Millards, whatever has been, whatever the claims is there or is not there, they stand extinguished. Only thing, they'll be treated. My learned friend wants, your lordship can observe that all these demands stand extinguished subject to resolution plan. I don't have any difficulty with that. Because any which way, Millards, after completion of 1 year, I have already discharged all my debt by paying this 30 crores because I have to pay this 30 crores within 1 year. And I have paid since March 2021.
Malad, on this issue regarding that if I have not filed any claim, then I am not entitled to anything, Malad. Malad, here in this case, exactly similar thing, Gujarat VAT Act was subject matter. There the department has filed, has lost the claim belatedly. In any case, the plan was approved.
Lost a claim, sir. The whole difference is that you don't lodge a claim and you compare it to the case that lodged the claim.
But my lord, here in that case, the Honorable Supreme Court has also laid down the principle that the statutory authorities prior to 2018, they were not required to lodge any claim. That was the specific finding. On the ground that it must be reflected in the accounts and the RP ought to have taken that into account. Having not done so, the plan is faulty one and ought to be nullified, and that has been nullified in that judgment.
We can't decide. You've never come to any court claiming that.
I have not challenged that plan itself.
Even here, that's why you can't draw parallel. Here, you seen the appellant, name of the appellant here?
Yes, my lord.
You are not.
So they challenged the plan.
You had gone to the Supreme Court. You had gone to some other court. Challenge the resolution plan, you may have got an order like this.
So, Malad, today what I
presume an order in your favor like this without a Supreme Court or any other superior court passing that order.
Malad, today what I am saying, let all be governed by that plan.
Everybody is governed by that plan. Why should we clarify it?
Well, today my lord is quashing the demand altogether.
Correct, because you have not made a claim, sir.
Well, I am not.
If you have not made a claim, how will you be covered by a plan?
My lord,
you're missing the whole point, sir.
My lord, may I read
here, Gujarat case, they had filed a claim.
But
you have not filed a claim. How can you draw parallel?
Right, I'm just only playing one paragraph I'm placing and leaving it to your lordship to decide.
That plan is not subject matter before us. That plan is not before us.
No, my lord, I'm only contending.
We cannot adjudicate that.
I'm not putting that, my lord, for adjudication.
Sir, if you have not filed a claim, you will not be covered with the plan. As simple as that.
My lord, I just
in the Gujarat case, they filed a claim and therefore they were covered.
But may I place also only one paragraph that will
place.
Paragraph 23. Prior to amendment by notification dated number so and so dated 3rd July 2018 with effect from 4th July 2018, sub-regulation 1 of regulation 12 read with sub-regulation 2 provided that a creditor shall submit proof of claims on or before the last date mentioned in the public announcement. Sub-regulation 2 was amended with effect from 4th July 2018 and now it reads a creditor shall submit claim with proof on or before the last date mentioned in public announcement. The regulation have to be read as a whole and not in a truncated manner and interpreted in the light of statutory provisions of the IBC as interpreted by this court. This court has time and again held that the timeline stipulated in the IBC even for completion of the proceedings are directory, not mandatory. Now, my lord, can you turn 24? In this case, claims were invited well before 5th October 2017, like the present case, which was the last date for submission of claims. Under the unamended provisions of Regulation 12(1), the appellant was not required to file any claim. My lord, kindly mark here, the appellant was not required to file any claim. Read with regulation 10, the appellant would only be required to substantiate the claim by production of such materials as might be called for.
So you've never challenged this plan. These are the grounds on which they were challenging the resolution plan in that case. Where have you challenged the resolution plan?
My lord, that's an undeniable fact. I'm not.
In a case where you challenge a resolution plan, please read this judgment even 20 times to us. We will read it with you.
My lord,
You're missing the point. Today, the case before us.
I'm not challenging that plan, my lord. I'm saying I will be governed by that plan.
This judgment is only in the event that you challenge the plan.
Yes, ma'am.
There, the state went before the Supreme Court challenging the plan.
Yes, ma'am.
One of the grounds while challenging the plan was all that you're reading now. So if you file a petition challenging the plan, you can read this judgment. You can argue, I was never obliged to file any claim. These claims were invited before 2017. In terms of this judgment, I never had to file a claim. I was never called upon to prove anything. Therefore, the resolution plan is bad. Please quash the plan. If whenever you file such a petition, please cite this judgment. Your arguments will be considered in that on that stage.
Today, what my learned friend has
Today, we are dealing with his petition. We will have to answer his.
Here, my learned friend had said that 30 crores has been accounted for all the creditors. Now, state is one of the creditor. Is he making the statement we are not there in that 30 crore, Malay?
Sir, if you should know what is he making
plan, I'm not previewing the plan.
You know whether you filed a claim or not.
Malay, claim I was not required to. 30 crores, whether I'm in that or not.
You're not answering the question. I'm sorry. You're only saying you're not required to. Did you file a claim or not file a claim? That's the end of the matter then. Don't go on beating around the bush. Here they filed the claim, they filed it late.
Malay. Here, my lord, 30 crores has been accounted
in his petition, we're not required to answer your point about the resolution plan not being valid. Let's be clear on that.
My lord, I just only one submission that if I'm included in that 30 crores, let it be there.
Anyway, you argue whichever way you want. This is the way you want to argue. No problem.
My lord, I'm not.
Go ahead.
My lord, my submission, I'm not challenging the plan.
All right.
Today, my lord is quashing the demand. I only pray that subject to the plan. If I'm that in that 30 crores, let it be there. I'm just that submission I'm making.
All right. You say the prayer in the present petitions is that in the light of the orders already passed with this court involving this very petitioner, that is the order dated 8/12/2022 in writ petition civil 1553 of 2022 and batch, the impugned demands raised by the opposite parties that is the Commission of Sales Tax Orissa for tax periods 1st April 2007 to 30th September 2010, bracket writ petition civil 7086 of 2016. Just give me each of the periods, please.
All the periods, Milods, are 1st April 2007 to 30th September 2010. Same period.
Same period, is it?
Yes. The chart your lordship may refer to, one-page chart that
should be quashed. All right. Under the CST Act, the OET Act and the OVAT Act should be quashed. Paragraph. The fact of the matter is, similar demands under these very statutes for different periods have already been quashed by this court by the aforementioned order. Paragraph. Today, Mr. Padi, learned counsel for the department, referred to the decision in State Tax Officer versus Rainbow Papers Limited, 2022 SEC Online SC 1162, and submitted that inasmuch as claims were invited in the present case prior to 5th October 2017, when there was no notification in terms of which the department had to file a claim, the dues of the statutory dues owed to the department should be taken to be covered by the corporate insolvency resolution plan. Corporate insolvency resolution plan, bracket CIRP, that has been approved and finalized for the petitioner company. Paragraph. Mr. Acharya, learned counsel, the petitioner points out that unlike the facts of State Tax Officer versus Rainbow Papers Limited Supra, where the tax authorities in Gujarat had in fact filed a claim, which was belated. In the present case, admittedly, no claim has been filed by the department. Full stop. He submits that in terms of the CIRP finalized for the petitioner, a sum of rupees 30 crores was reserved to be paid by the petitioner for discharging the dues to corporate operational creditors. Full stop. He further states that the said sum of rupees 30 crores has already been paid by the petitioner in terms of the CIRP, therefore, thereby satisfying the monies owed to all operational creditors of the petitioner. Full stop. Paragraph. The court finds that the CIRP will obviously apply only where there is a claim by an operational creditor. Full stop. If there's no claim filed, then the creditor cannot possibly contend that the CIRP covers the claim of such creditor. Full stop. Paragraph. If the department wants to take advantage of the pronouncement in State Tax Officer 1 versus Rainbow Papers Limited, the department ought to have challenged the CIRP before it was fully worked out. Full stop. In the process of such challenge, reliance could have been placed on the decision in State Tax Officer versus Rainbow Papers Limited to contend that the department's claim should also be taken to be covered by the CIRP. Full stop. With this department not having till date come forward to challenge the CIRP, the question of this court directing that the CIRP already finalized and approved for the petitioner company should be taken to cover the statutory dues owed to the department does not arise. Paragraph. That view of the matter, following the order already passed with this court on 8/12/2022 in WP Civil 1553 of 2022 and batch, the court quashes the impugned demand, the impugned assessment orders and demands challenged in these petitions. They accordingly allow no orders to pass.
Okay. Pass to matter item 72.
Item 72, my lords. The Bhubaneswar Development Authority, my lords, challenges the order of honorable single judge. My lords, that is at page 40, my lords. It's a dispute, my lord, concerning allotment of double plot by the Bhubaneswar Development Authority on the basis of filing of the false affidavit by the allotment. There, my lords, this matter was under adjudication by the Honorable Learned Lokadala. Learned Lokapal recommended for action. Thereafter, we have initiated a proceeding for cancellation. That cancellation proceeding, my lords, that was notified in the newspaper also, and that is there in page 24, my lords. So, for my lords, that after this notice, proof was issued, And thereafter, my lords, the cancellation order was passed in what is available as page 29 to the writ appeal, my lords. I'll have a glance to that one.
Notice is not gone.
I think Mr.
I am for the respondent. For the actually facts are not clear. Let me just it's not a question of double allotment. I was initially it is their own case also. I was allotted with a plot 317 of 3000 square feet. I wanted an exchange with the adjoining plot. That is also for 3000 square feet. That was permitted by the appellant authority, Bhubaneswar Development Authority. The second plot, 318B, is a third party purchase by me. Owner is one Anirudh Patnaik. And Milord, it was sold to me, not that it was allotted by the BDA to me. Milord, it is their own pleading. Your Lordship may kindly come to ground number at page 4. Ground number B, subpara 2, Milord. 1 and 2. Milord, it is their own pleading. The respondent petitioner was allotted plot number 317. She was allowed to exchange plot with the owner of plot number 318A, and accordingly, the respondent petitioner became the owner of one plot 318A, which is not in dispute. Subsequently, the respondent petitioner got allotted plot number 318B. This should not be allotted, Milord. This is by way of third party transfer from Aniruddha Patnaik. Milord, this sale is not prohibited. Anybody's sale and purchase is a continuous process. The owner of the adjacent plot wanted to sell me, I took it. So no exception. That is why, Milord, the Honorable Single Judge, Your Lordship, and they have also approved the plan. Your Lordship may kindly turn to the BDA's own letter. They have approved it purely on a misconception. They proceed. Page 21, Milord. That is of 2002. After 17 years, Milord, page 21. This is the plan approval order.
No. Mr. Acharya, I think what they're trying to imply from the impugned order, which is at page 18.
21.
18.
Page 18, yes.
That even your purchase of a subsequent plot, of another plot subsequently, that would violate the condition that you're not expected to own more than one plot.
No, Lord, that is not a normal allotment by the BDA. They cannot allot me 2 plots. Let's suppose I purchase one from a person is in need for the daughter's marriage. Your Lordship may kindly look at for the daughter's marriage. That is also the Honorable Lokpal has said. Your Lordship may kindly turn to. It is for the daughter's marriage of one Anirudh Patnaik, who is the owner of the adjoining plot, adjacent plot, Milord 380B. He sold it to me. That was permitted. Just a minute. That was permitted by the BDA. That approval, the approval of transfer, Milord, they say that it's a sale and transfer purchased by me, not that it was allotted by the BDA to me. They will not misconstrue it as if it is a fresh allotment, the second allotment. It is not that. It is their own case also. Your Lordship may kindly come to the third party transfer. They say it is a third party transfer. And at page 6 also they have reiterated. The ground number C, the Honorable Single Judge failed to appreciate the fact that the cancellation of plot in respect of 318B is a separate and distinct one and was purchased by the respondent petitioner. But if it is a case of purchase, there is no question of allotment by the BDA. So it can be construed as double allotment. That is how
explain this, but this is important.
And say that no, the second allotment, it is not an allotment. It's a sale and purchase which has been approved by the BDA, Milord, on the basis of facts. That's all. And they say that because you said that you don't own any plot, so therefore it is entitled to be cancelled. But this is clearly on fact also. They say page 6, ground number C, is a distinct plot and it is Milord purchased by me.
Let's ask. Yeah, we'll ask Mr. Mahapati. Yes.
May I submit, my lords?
Yes.
So far allotment in BDA is concerned, suppose that there is an allotment made. So one allotment made, you have to file an affidavit that you got a plot from BDA. If somebody wants to purchase a plot on third party transfer basis, then they, as per the provision of the brochure, they are to take NOC from the BDA. While insisting NOC for purchase of that plot, BDA insists on affidavit that whether you own any other plot under the BDA Bhubaneswar or Housing Board or any other scheme, this has been made for the purpose that more number of people should be given that benefit. One person may not get that, get double, triple, fourth plots.
No, is that prohibition about not owning another plot applicable when you make a private purchase?
Well, that is exactly what my law says. But kind of a glass to them. Then
his specific contention is
that I understood, my lord. I understood.
Only
what my learned friends
you can't seek a second allotment if you already own a plot, but you can certainly go on a private basis.
Yes, what my lord, my learned friend says, I appreciated. But here in this case, my lord, I am submitting it. Why it has been cancelled? That is what. No, that is not the reason. My lord, kindly have a glass to the order of cancellation. Only 2 lines. It's not cancellation because of this. Well, that is at page 31, 30 and 31.
Yes.
Well, last line. And I'm making it very short. And whereas in her affidavit shown on 20th/3/2001, she had admitted that she was in lawful and peaceful possession of plot 318A. Then the second, whereas plot number 318B was allowed to be transferred in favor of Srimati Sarkar on the basis of the affidavit shown by her on 28/5/2001. 2 affidavits. In this affidavit minus I enclosed.
No, that's there in the earlier paragraph.
That's earlier.
And whereas she owned a plot.
So he filed a false affidavit. That is what.
Just read that.
And whereas she owned a plot by virtue of allotment of plot number 317 on 30th/9/2000, which was subsequently exchanged on 15/3/2001 with plot number 318A. That has been done, manner. There is no, because it constitutes single plot. The affidavit sworn on 28/5/2001 to the effect that she neither owned or possessed any plot within the master plan area of Bhubaneswar authority is false to her own knowledge. But the brochure itself classified that if you own a plot allotted by BDA or within the municipality area, within the area, the second plot cannot be. Here in this case, what my other friend did.
Plot, sir, again, the distinction what is trying to make is this.
Yes.
Is there a policy saying the minute one plot is allotted to you, you cannot buy any other plot? Is that a condition?
So to my knowledge, my lord, there is no such.
If there is no such condition, then this
here in this case, my lord,
the affidavit makes no difference. Whether he correctly said in the affidavit, I own another plot or did not own another plot, makes no difference.
All that, my lords, may be taken up some other day so that I will get that information, whether any specific, I think to my knowledge, my lords, whatever it was filed, I'm concerned so far that Bhubaneswar development activities are concerned. To my knowledge, these are
Mr. Acharya will just note your submission and say that he wants time to find out. All right.
Let us find out that. What Mr. Acharya raised a good point.
Mr. Acharya, appearing for learned senior counsel, appearing for the respondent, submits that while there could be a requirement while seeking allotment of a second plot that the person seeking such allotment should not own any plot at all. There is no such bar to a person having been allotted a plot by the BDA, seeking to purchase another plot privately from another plot holder. So in the present case, he points out that the so-called that the second plot, namely plot number 318B, was not single quotes allotted unquote to the respondent, but was purchased by her through a registered sale deed. Full stop. Therefore,
he's the allotee.
All right. No. By a registered sale deed, you must have bought it, sir.
No, they have permitted. Actually, Milord, as per that, they permit the transfer. I have registered it, Milord. The building has been constructed
by a registered document with prior permission of BDA. Full stop. He accordingly submits that there was no bar to buying the additional plot, notwithstanding that the respondent may have been allotted earlier plot number 318A. Paragraph. Mr. Dayananda Mahapatra and counsel appearing for the BDA, appellant BDA, wants time to seek instructions on the above submission. July 4th.
Your lordship may take it.
In fact,
Appearance the bidding is quite. He also now wants to sell it.
In fact, my lords, with due humility,
It'll appraise in July. It'll fetch more, sir.
Or candidate right to summer vacation.
With due humility also.
It's all right, sir.
With humility also, I cannot develop it because that is the reason for which it was allowed.
That's correct. My friend, Mr. Mahapatra is very fair. I don't think with his long experience with the two authorities and the housing board, I don't think he will not dispute. Anybody can have.
No, that is the reason I can.
It's sale and purchase. How
not raising your
restricted sale and
not raising or anything else, but the order of rejection on that basis
comes
only.
to the crux now says that no, it's a let it be disposed of. Why should it be kept pending in the file? 19 he filed the appeal. Had he been that curious to pursue it, after 4 years it is being listed. So your lordship I don't think he can improve upon his case. Sale and purchase, lady is 85 years old. I now also want to sell it, to some other person to have my personally.
Right, sir. Right. Okay. It's all right.
Consider it,
Item 73.
As I have taken instruction because the direction of the Honorable Single Judge has been complied with. Now the question becomes academic.
You said. It is seen that the impugned order of the learned Single Judge has already been implemented. And therefore, the issue raised has become academic. The writ appeal is disposed of as such. Right.
Next. There are two covered materials last time, yesterday.
Mr. Mohanty had to find out.
Item 47 and 63.
You forgot your specs.
No, it is there. Sorry. That is why. Here, my lord, your petitioner are a bona fide purchaser, but the show motor revision initiated after 24 years.
No notice to you.
And without implementing the party and also. And your lordship.
That's right. That's all right. On the short ground.
24 years, your lordship categorically held that there is no fraud at all in the impugned order.
That's a separate thing, sir.
I am passing over the order.
No. Are you a subsequent purchaser?
No. Prior to cancellation, I purchased. Prior to cancellation, I purchased in the year.
Correct.
Yes.
So you're a purchaser.
You are purchaser prior to cancellation.
Yes.
So that's a different ground, sir. That nothing.
No. I am a purchaser in the year 1980, my lord. But cancellation was made in the year 1998.
Correct.
After 15 years, my purchase.
So you're not covered by that Asin Das and all that.
Yes, that is covered. That Paramguri itself is covered, my lord. That is after 25 years.
Once it has to be cost and demanded. After the ADM hold that it is.
No, the ADM nowhere hold that it is a fraud, my lord. It is the only.
No. There are two different things. Your case is that you're a purchaser.
That order, there is also purchaser, my lord. That is also purchaser. But the statutory provision itself provided that 7A cannot be initiated after 14 years.
That means he wants that your lordship should directly allow it. That cannot be, because in other cases also, this ground, your lordship is leaving it open to the ADM to decide, take a call on this ground. And if he pass any order against him, he will again come to the court.
All right.
Now it cannot be.
Your lordship.
47 out of
63. Their amendment also they have raised, and that point was
they have not sent it back.
And your lordship, last occasion, another case, your lordship only giving observation that the government has a liberty to raise 3B. Resumption.
No. That is a different thing. What he is saying, that is in the second round of litigation, your lordship is saying that if fraud finding
second, it is a first round.
First round, so simple remand. Why are
And
you
a simple
insisting for
remand,
other?
so 98 is that is his jurisdiction
That
itself.
point is not adjudicated by the ADM in the impugned order. Let him say
Impugned order, yes. That limitation ground was also there. Now they are.
Where is the avowment about when you purchased it?
In read petition.
Item 47.
Jagannath Panda.
Government paragraph 5, my lord. I have quoted the entire, paragraph 7.
No, it
Page
is not
5.
annexed at all.
Page 5, I have quoted the statutory provision from the above provision.
No, Mr. Samantray,
Yes.
we want to know when have you purchased? Where is the pleading?
I have purchased. Paragraph 5. I have purchased and also mutated in my favor.
That is sale deed is important.
Date, sir.
Date of sale deed.
Date of purchase. Where is the registered sale deed?
Paragraph 4, your lordship can see. The land measurement transfer under annexure transfer in favor of the petitioner.
Dated 7/5. Okay.
But that is not
the case of the petitioners.
My lord, but doubt is that that sale deed is not enclosed.
You have not filed a counter.
I have mutated.
That's a different thing. Mutation is
But you have not filed any counter, sir.
After verification.
We'll go by what he says. All right.
Councilor already recorded in my favor.
The petitioners state that they purchased the plot in question. That is plot number 2704/3234 and the Khata number 805 bracket 621 by 136 of Moza Andharua at measuring AC 0.500 decimals by registered sale deed dated 7th May 1980 from the original lessee. Full stop.
And also recorded, my lord, on the annex.
They say that their names were also entered in the record of rights paragraph. It appears that exercising the suo motu provisional powers, the additional district magistrate Bhubaneswar, bracket ADM, has, by order dated 30th June 1998, in revision case number 704 of 1998, cancelled the allotment made of the plot in question in favor of the original lessee, who happens to be the vendor of the present petitioners, without notice to the present petitioners. Full stop. With the above facts not being disputed by the state by filing any counter affidavit, the court proceeds on the basis of their correctness and quashes the impugned order dated 30 June 1998. Full stop. RC number 704 of 1998 will now stand restored to the ADM Bhubaneswar, where it will be listed on 24th April 2023. On that date, the petitioner will appear before the ADM along with a downloaded copy of the present order. Full stop. The ADM is requested to proceed in accordance with law thereafter and dispose of the RC within a period of 4 months thereafter, till such time the interim order passed with this court on 7th November 2012 will continue. The court clarifies it has not expressed any view on merits of the matter.
67, that particular order itself already passed, my lord. Your lordship can see by a challenge by some other co-purchaser.
67 or 63? What is the
63, 63, sir.
63.
That particular order challenged by other co-purchasers that has already been passed in respect of the scheduled land.
All right.
So that order may be implemented in case of
the challenge, the present petition.
Same order, my lord.
Yeah, it's an order dated 31/3/1998 passed by the ADM Bhubaneswar in RC number 67 of 1998. So that very order stands quashed in the instance of other purchasers by the order dated 7/2/2008 of this court in writ petition civil 715/2008. Full stop. The quashing was on the basis that the suo motu revision was initiated after a lapse of 25 years. Full stop. Following the said order, the same impugned order vis-a-vis the present petitioner.
The last line, my lord, since it was held by the Honorable Court, so far it relates to the land purchased by the petitioner.
That's what he said that.
Weekly list item number 19.
Maybe the lot 19. My lords, on the last date, to beg apologies, my lords, there was a slight confusion created, my lord, on whether the employer or the official liquidator had filed the Vakalatnama. My lords, the official liquidator had filed the Vakalatnama and he is the petitioner number 1 in this petition, my lords. My lords, now.
What remains? Why should you challenge? If you're already in liquidation, then why should you challenge this?
My lords, they have filed, the Watman or the opposite parties have filed this particular case before the labor court. My lords, my point is the labor court doesn't have the jurisdiction to pass the order, my lords. My lord, they have claimed wages and bonus. As I said, like item 6 of the second schedule it deals with all the matters except covered by the third schedule, and bonus appears as item 5 in the third schedule, my lords. And the question of entire bonus could not be decided by the labor courts, my lord. It should be decided by the tribunals, and any claim if the opposite parties have, they should make before the liquidator, my lords, according to the Cooperative Societies Manual Act.
No, the liquidation proceedings started even before they approached the labor court.
My lords, the liquidation procedure is still going on, ma'am. It's not over.
When did it start?
My lords, my lord, before they approached the labor courts, my lord. I mean, the liquidation process was going on.
You have a list of dates. Prepare a list of dates, sir. You also prepare a list of dates. All right, stay on board. Precise dates you give. When the liquidation proceeding started, when the claim was filed. Yes.
My lords.
Weekly list item 20.
In this case,
there he is.
The present petitioner is the secretary of the institution, that is Satyapir Dargah, Musk and other institution. When he was going to make some construction development work in the said premises, some of the miscreants of the said area, they disturbed their not to make any construction, or which he filed one WTO before the Wakaf tribunal. Man kindly see Annexure 1, page 6. In the said the tribunal has been pleased to pass the judgment, that is page 12. Page 12, my lord.
Yes.
The present should be and same is dictated on contest against the opposite party 1 to 14. The cost is not about the applicant has no such right to construct latrine wajukhana adjoining to the wall of Mazar Sharif by causing blockage to the pathway to the Mazar Sharif Pirastan situated over the shootland. However, the Odisha Board of Wakaf has every right to renovate the old building to construct wajukhana, latrine and cut tree standing over the shootland, though itself or by any person or committee duly authorized for the welfare of the visitors, devotees with causing inconvenience to them. The opposite party 1 to 14 who are creating disturbance against the present petitioner, they have been restrained by the tribunal as per the order. So it is also held by the tribunal. The chief executive officer Odisha in this order Wakaf is directed to appoint Mutawalli under section 63 of the Wakaf Act 1995. So yet no Mutawalli has been appointed by the board. So this present petitioner which has been selected by the villagers, he is not doing any work as because due to passing of judgment by the Wakaf tribunal. So after obtaining order, he approached the CEO, Chief Executive Officer of Board, to appoint Mutawalli, or he filed one resolution copy in which he has been selected as the secretary, that should be approved. So yet nothing has been done, for which the petitioner filed the writ application. As this is imposed by the board, that I have no such authority to do any work, so I cannot do any work unless Motoli is appointed or his resolution as the secretary may be approved by the board of workers.
Well, I am for the opposite party, madam. In this case, madam, due to conflict between the petitioner and the opposite party, the board has not appointed the Matwali. In the year 2016, my lord, board has appointed one administrator to look after the day-to-day management of this institution, my lord. So he's managing all the affairs of this institution. Already appointed, my lord, 2016, man. Sabir Hussain 1.
This is a 2016 order.
Yes, my lord. My lord, in the year, there is a conflict between the two groups, my lord. One group is petitioner and other group is opposite party in WTOA number 15 of 2014. So board has not appointed in the year 2014 for day-to-day management.
Yes.
So I may be permitted to instruct from the petitioner whether this administrator is doing the job of said work.
Do you have information?
Already I managed the day-to-day affair of the one Sabir Hussain, man.
Since long, whether he's alive or not, I couldn't know.
Are you aware?
He's also old man. I know him. Which was old.
To take instruction.
Yes. Right. Stay on board. Stay on board.
Item 21.
There are two writ applications, Your Lordship. In the first writ application, on 7th of February 2023, I have filed a rejoinder along with the one I number 1736 of 23. That has not come on the list. On the second item, sub-item, and for the opposite party, a copy of the writ application may be directed to be summoned. Till that, I have not received copy of it.
I'll serve it now. My lord, I'm on behalf of Mr. Rai. My lord, kindly.
Have you got a copy of the counter filed by him? The first matter.
Rejoinder.
I think you have to
Yes, my lord. I've received it. I'll serve the copy of the second.
All right. Next part. Please stay on board.
Obliged.
Item 22.
Item 22 on behalf of opposite party, I pray 1 week time.
So you are for the petitioner.
I am for the petitioner.
Lord,
Mr. Mahapatra is out of station due to his personal difficulty, my lord.
All right. Stay on board.
Item 23.
My lord, it will come next week.
Next week.
Interval to continue.
Not passing any order.
Item 23.
Your Lordships, in item 23, Mr. Subhashish Mishra is engaged, so his personal credit matter can be taken up on 6th of March.
All right.
Oblige, Your Lordships.
We don't have to keep a date. Stay on board.
Old matter item 24.
None is dismissed.
Item number 25.
May I pray for a Passover for the day, Your Lordship?
Right.
Let it stay on board.
All right.
Item 26.
26, no instruction.
No instructions.
Item number 27.
Memo taken on. No instructions. Tomorrow, all this right of the children is This is the last matter.
762 of 2004.
The memo is in which one?
First matter, 564.
564, you say memo on record. Disposal. Second one, none of these.
Item 28.
None of this.
Item 29.
May I please your lordships? The challenge here is the order of the learned member Board of Revenue confirming the appellate order by the learned sub-collector, wherein mutation directed in my name has been set aside, your lordship. Admittedly, my predecessor in interest had got a Jawan lease in 1977, Annexure 1, your lordship.
Infructuous, because Jawan lease matter we cannot.
Infructuous. That lease still subsists is my humble contention before my lords. Annexure 1 is the lease, your lordship.
No.
Subsequently, there was major settlement in the area. And
there's no interim order, nothing, sir. Notice is not even gone. Since 2007.
Notices had gone, your lordship.
Sorry?
Notices had gone, your lordship.
1 minute. See the hard copy. See the order issue notice. Yes, even the paper. Take out the order where notice is issued, sir. No such order. Don't come up once.
Notice that in the notice. There is no order. May I humbly pray your lordship? Your lordship, admittedly, the remedy that was pursued for the mutation case, that was not available under law. The remedy is under section 15B before the learned member Board of Revenue. My lords may kindly permit me that.
All right. Counsel, the petitioner seeks leave to withdraw the present petition with liberty to approach the Board of Revenue under section 15B.
Your lordship, of the Orissa Survey Settlement Act.
Survey Settlement Act. This post of is withdrawn with liberty is prayed for.
The limitation may be favorably considered.
All right. You see, the plea of limitation would be considered by the Board of Revenue, keeping in view the tendency of the petition.
Deeply obliged, your lordship.
All right.
Lord, I'm permitted to submit one thing. There is a noting in my file that this particular land is already allotted to Dhamra Port in Chandwali. So it is already leased out to Dhamra Port.
My lord.
Anyway, let him take his chance.
My lords. Today I got from the Bhulek the copy of the ROR, which doesn't show that. That is why. Deeply obliged, your lordship.
Okay.
Item number 30.
Lordship, last occasion, Honorable Court granted time to state for filing counter affidavit. We don't have knowledge. A copy may be served to us. And my lord, may kindly grant for 2 weeks
1 minute, sir.
For regender filing.
1 minute, sir. Are you for the petitioner?
I'm for the petitioner. My learned friend is for a different matter, I guess. Sir,
no, we have now called out item 30.
Item number 30.
29, your lordship.
No.
We have called out item 30, sir.
Your lordship, your lordship.
Don't please interfere in 30 now. Yes.
You are 30.
30
in item 30, are you appearing for the petitioner?
I am not appearing for.
Then please keep quiet. We'll first find out who's appearing for the petitioner. All right.
Please, I mean on VC, my lord. I am appealing for the petitioners, my lords. Last occasions, my lords, directed to the State Council to file the counter, my lords.
No, this is 2009 matter, sir.
IDCO has also filed.
All together, my lord. 2009 as well as 2017 are together, my lords. It's all the cases lordship has directed to lordship. May kindly see the last order passed in.
This is levy holding tax. It's over.
Writ petition 1780.
Holding tax matters are over.
Lordship, I am appearing for IDCO. I'll just show one gazette notification. The entire case may be set to rest. The government of Orissa in 2015 has taken a call on this very same issue and issued a government of Orissa notification. I'll show it to your lordship. It is there before your lordship.
That
It is
notification is under challenge, my lords. In which
just one. It will take just 1 minute.
Yeah,
It's in
that-
date petition
that
number
is very
12206 of 2017. That writ petition is listed today before your lordship. 12206 of 2017. Your lordship will have page 40. There's a housing and urban development resolution dated 13 November 2015. Has your lordship got that? Lordship, I'll just read out the last two paragraphs. In ULBs where civic amenities are provided by the ULBs in the industrial areas, townships property tax holding shall be assessed by the ULBs as per the provision of the Act and rules made thereunder. Demand notice shall be served to the industrial unit and the details of the demand raised be shared with the IDCO property tax holding shall be collected by the IDCO and tax so collected shall be shared at the ratio of 50-50.
It's begging the question, the validity of this resolution is under challenge, sir.
Absolutely, my lord.
Then this is under challenge, you can't refer to this.
Lordship, the older writ petitions,
No, in this writ petition,
my
this is
lordship
challenged.
is there.
No, in this 12206, it's challenged.
Yes, ma'am.
And before this date, you could not have collected holding tax then? If you're seeking to justify only by this resolution, then for the period earlier through this, there was nothing.
My case was different. My lord, also
My lord, may I assist? Lordship, may kindly see the order dated 2nd May, my lord. 2nd May.
Yes.
Yes, 2nd May, lordship. It is seen that the challenge in the writ petitions filed in 2017 is to the levy of holding tax by virtue of resolution dated 13th November 2015 of the government of Odisha.
Why no counter has been filed? Last opportunity granted.
Yes, absolutely, my lord. So that counter has not yet filed by the government.
No, that is there, but here the Khordha municipality has filed the affidavit on behalf of the H&UD department.
No, we noted all that. We said the state government has to file because validity of your resolution is under challenge.
Lordship may grant me 4 weeks time.
That's the last opportunity, sir.
My lord.
Just missed out somehow.
I think we'll pass that standard order. You see, on 2nd May 2022, the following order was passed in this batch of matters. Today, Mr. Manti pleads for one more opportunity. If the counter affidavit is not filed on or before 26 June 2023,
That's be
cost of rupees 25,000 will be paid to the Orissa High Court Welfare Fund. List on the rejoinder that to be filed for the next date. List on 12th July. Interim order to continue. List in the regular matters. The regular list.
Much of it.
My lord, 5th April.
Just giving the dates.
12th July.
12th July.
Right. Item number 31.
May I please, your lordship? This is the third round of litigation for the petitioner. The petitioner who is working as a lecturer in the opening up a 3 college.
Single judge.
Single judge matter.
But it can be disposed of, your lordship. But if your lordship wants, it can be disposed of.
Meaning?
Why I'm saying so, the petitioner who is working as a lecturer in the opening number 3 college, she is challenging Annexure 12 and 13 passed by OP number 3 and 4. 3 is the Director of Higher Education, your lordship. Now, prior to that, your lordship, I want to show your lordship the order of the case filed by the petitioner in the earlier occasion. Just forwarding the copy, your lordship. The same petitioner has earlier approached in WPC number 1515/2008, your lordship, which was disposed of on 5/2009. The entire controversy is, your lordship, in the absence of a state selection board candidate, can the petitioner continue on the post of lecturer or not? Now, I won't take your lordship much time. I will just place a relevant paragraph
at the second page, Your Lordship, the penultimate paragraph. I will just read from this. Again, sorry. Yes, my Lordship. I'll just read the second paragraph, Your Lordship. According to the learned counsel for the petitioner, the letter issued by the principal of the college, White Annexure 9, cannot be said to be an order of appointment of the petitioner as lecturer in Odia in Bonaigarh College in terms of the directions given by the sub-collector Bonai, White's letter under Annexure 6. Rather, the same can be construed to be a letter of engagement of the petitioner on contract basis as and when necessary, and that too for a short spell of time only to cover the classes, and her services can be extended for or terminated at the whims and caprice of the principal of the college. This was not the spirit of the order of the sub-collector while disposing of the representation of the petitioner in terms of the order of this court. Apart from that, we may make it clear that the petitioner shall continue in the post until the vacancy is filled up by a selection board candidate. We are surprised to note that it has been mentioned in Annexure 9 that the petitioner is to get ₹40 per class, subject to a maximum of ₹1,000 per month, which is less than the minimum wages provided for an unskilled laborer. The government should not have granted permission to open or establish colleges which cannot pay minimum salary to lecturers. Mushroom growth of this type of colleges is not at all conducive to the development of standard of education in the state. I will skip out this part, Your Lordship. Now, pursuant to that, they have issued me the engagement order in consonance to this order, Your Lordship. Now, why I'm charging under 13 and 14, Your Lordship, may kindly see Annexure 30 at page number 34 of the writ application, Your Lordship.
Yes.
Consequent upon the joining of Sri Pavitra Mohan Garnayak as senior lecturer in Odia in this college on 9/11/2009, as per Director of Higher Education, Odisha order number so-and-so, against existing vacancy caused by the transfer of Dr. Chaudhary Ranjan Kumar Das from this college, service of Srimati Gitanjali Pradhan as per Bonaigarh College order number so-and-so and modified order number so-and-so in compliance to the order of High Court order number so-and-so is terminated with effect from 9/11/2009. I shall kindly note first the order which I have placed. Prior to that, they have given me appointment on 7th of August at Annexure 12. Now they have terminated me on 9th of November, Your Lordship. And now Annexure 14, the Director of Higher Education has transferred a lecturer who is not a state selection board candidate. My only condition is, Your Lordship, in terms of the 1974 rules, only a state selection board candidate can be appointed against a vacant post, which is approved by the government.
But why are you bothered about all that?
Yes, my
your services have been terminated.
No, I'm coming to that, Your Lordship. Now, pursuant to that, I have filed this writ application and another content application was pending for this honorable court. Now, because of the non-compliance of this order, that Annexure 14 has been kept in abeyance. Now,
by whom?
My Lordship?
Kept in abeyance by whom?
By this honorable court. Because
where is that order?
My Lordship?
Where is that order?
Actually, I don't have the copy of the order, Your Lordship. I'm just forwarding where they stated that.
No. Where is the order? What is this? Order in this writ petition, right?
My Lordship?
There must be an order in this writ petition.
No, Your Lordship. In contempt case number 211/2009, Your Lordship.
How can in a contempt case this order, you have challenged it here in this writ petition?
Yes, Your Lordship, because...
How can it state in the contempt petition?
I'm saying so, Your Lordship. I'm clarifying it. Now...
The contempt petition is here. 1 minute, let's just see. Oh, there's no contempt petition
Yes,
here.
Your Lordship. I'm coming to that, Your Lordship, because the true spirit of the court's order was that against a sanctioned post, only a state session board candidate can be appointed.
Sir, how is all that? Your services have been terminated.
No. I've been again re-engaged, Your Lordship. Yes, I'm forwarding, Your Lordship.
You've already been re-engaged?
Yes, Your Lordship.
Then all this is infructuous. This writ petition is infructuous if you've been re-engaged.
Yes, Your Lordship. My only submission is, Your Lordship, let them... I will continue with my post. Let them, if they want
re-engaged, how can your writ petition challenging your termination be alive. It's
Absolutely.
purely academic.
I do bow down, Your Lordship.
That's the end of the matter. You say counsel the petitioner states that subsequent to the filing of the present writ petition, she has been re-engaged as lecturer.
Yes, sir, in Odia.
Lecturer in Odia. So with that view of the matter, the main prayer in the present petition has been rendered infructuous and the writ petition is disposed of as such. All right.
Can only Lordship make one observation? Let them just comply with the order passed in the earlier time, which I was placing the order, Your Lordship. Let them comply with that.
No, that you pass. It will pass in the contempt petition or wherever that is pending, it will get passed in that. Yes.
It is not pending, Your Lordship. Basically, they were acting in adherence to the order passed in the WPC
So
number.
there is a contempt petition, you follow up on that. In that.
That has been disposed of, Your Lordship. That has also been disposed.
Item note 32. 32.
32, my lord. There are two orders regarding obtaining instruction by the London State Council. First of such order is 17th of April 10 and 19th of April 2022. But the sort problem here or dispute here is, my lord, the initiation for allotment of a land plotted scheme was initiated in 2010, the Annexure 1, page 6. The petitioner was interested for a particular plot. He submitted his bid, my lord, and application was submitted with deposit of 10,000 rupees with the opposite parties. That application form is page 9. Now, my lord, I have said in the writ petition that they are not finalizing process and they have done away with this allotment, but they have not filed any counter nor they have communicated any letter to me. In this peculiar situation, if I can pray, Your Lordship, let me approach the ADM, who is the authority, and let them decide my grievance.
All right. Counsel, the petitioner seeks leave to withdraw the present petition with liberty to approach the authorities for redressal of his grievance. Disposed of is withdrawn with liberty is prayed for. The interim order is vacated. All right.
Item note 33.
Lord, I just request, my lord, let my application be considered in stipulated period. That's all. Otherwise,
If such representation is made not later than 3rd April 2023, it shall be considered in accordance with law, and after hearing the petitioner, reasoned order shall be passed thereon.
That will end the problem.
Within 3 months. Then.
Yes, ma'am.
All right.
33.
No instructions.
Item 34. The order passed by the London Labour Court under Annexure 10, case 33, is under challenge. The petitioner, while working in the cooperative society, was terminated on 36/2000 in view of liquidation of the cooperative society. Thereafter, an application under section 33C2 of the Industrial Disputes Act was filed. Lordship kindly peruse the order. The calculation sheet was submitted by the petitioner. That is at page 13. Lordship kindly peruse. Page 13. That is 3,07,990. And the detailed calculation is at page, it starts from page 14 and ends in page 18. The detailed calculation are given. And the reply submitted by the liquidator, my lord, as page 19. They did not dispute this calculation given by the petitioner, my lord. And they also did not submit any documents to justify their claim. Only they say that the petitioner is entitled to get an amount of rupees 98,448. So Lordship kindly peruse page 31, Annex of 8. They submitted that and the petitioner is entitled to get an amount of rupees 1,22,040 and he has been paid an amount of rupees 23,591 and balance amount is such. But to that effect, no document was submitted. That is also observed by the London Court, Labour Court, my lord. If your lordship will peruse page 36, paragraph 9 of the order, It is clearly stated that the OPW number 1 has not filed any documents in support of the case of the opposite party management, although he submitted that the applicant is entitled to get rupees 98,448.30 paise. But despite that, the learned court below admitted that the petitioner is entitled to get only rupees 98,448 and passed the impugned order.
That reason is given in page 37.
My lord. Page 37, man. Yes, ma'am. However, during the period of liquidation, the opposite party management has paid the consolidated amount to the applicant and finally terminated him from his service on 36/2000. The applicant has not rendered any service during the period of liquidation. So, taking all the facts into consideration, it can be said that the applicant is not entitled to get any claim. Well, I was terminated from service at the time of liquidation. So, question of working during the period of liquidation doesn't arise, my lord. When the liquidation process was started, I was terminated. I have given the termination order. That is at page 11. Owing to the liquidator of Balangir Regional Cooperative Marketing Society Limited, Balangir, that is 21/6/2000, the Deputy National Cooperative Society, Balangir Division, Balangir.
Have you got this 98,000?
No, my lord. Part amount has been paid.
What has been paid?
It is paid. That is at page 38, my lord. They have paid only 60,000. Annexure 11.
But there is if it's gone into liquidation, how do you expect to get this money?
Well, the office is functioning till now. Office is functioning. Notice was issued to them, and report is there that
who's appearing for them?
AD return.
Approximately 3 lakhs claim, is it?
3,07,000.
Just ask them to pay with interest if they've not paid already. That's the best part. You'll get all the interest from the date of the award. The present petitions have been filed by the former employees of the respondent. That is the liquidator Balangir Regional Cooperative Marketing Society. Aggrieved by the impugned order dated 4th March 2010, passed by the Labour Court Sambalpur. In ID Miss case number 12 of 2007 and other connected matters, all under section 33 capital C bracket 2 of the Industrial Disputes Act 1947 bracket Act. Each of the petitioners claimed approximately rupees 3.3 lakhs, but were awarded only 1/3 of those amounts claimed. Full stop. For instance, in petition civil 13065/2010, the petitioner was awarded rupees 98,446.30 by the Labour Court. Paragraph. Counsel to petitioner submits that there is no justification in not awarding the full claim amount. Full stop. He points out that the reason given, namely that petitioners cannot claim wages for the period during which the respondent unit was under liquidation, does not hold good, because with the commencement of the liquidation process itself, the services of the petitioners were terminated. Paragraph. Despite service of notice, valid service of notice, none is appearing on behalf of the respondent. Paragraph. Keeping in view that each of the petitioners has worked for More than 20 years?
My lord, from 91 to 2000.
For nearly 10 years. The court is of the view that the interest of justice will be met if the amount directed to be paid by the Labour Court is paid to each of the petitioners together with simple interest at 6% per annum from the date of the order, that is 4th March 2010 till the date of actual payment, which should not be after 2nd May 2023. If there is a delay in making the payment, then the respondent will pay further simple interest of 9% per annum on the for the period of delay. No, will pay simple interest at 9% per annum on the said sum for the further period of delay, till for the period of delay. Paragraph: any payment made to the petitioners already will be accounted for while making the above payment. Paragraph: it will now be open to the petitioners to seek appropriate remedies in accordance with law if the directions issued are not complied with. All right. This covers how many matters?
4 matters are there. 35, 36, 37.
Right.
Obliged. Item number 38.
Item 38, may I pray this matter might be taken up on Thursday. I'll take instruction, my lords, order dated 19/7/2022, whether that person can be accommodated in view of payment.
Or stay on board.
My lord, I am for the opposite party one, my lord. I am in BC, my lord. My lord, I have given the document pursuant to your lordship's order dated 19/7/2022. I have obtained information under RTI Act that 7 posts are there. Your lordship, I have given through my friend, my lord.
Let him take instructions, sir.
I am submitting that.
I have already taken instruction, that is why.
Item number 39.
Memo taken on record. Right. No instructions received.
Item number 40.
None of these dismissed.
Item 41.
There was a reference. Annexure 1 page 10.
During the pendency of writ application, the petitioner has been dismissed from service, and an order, the same petitioner has got an order from my lord's court. I am giving the copy.
That dismissal is on certain other facts, not pertaining to this period.
Sorry, dismissal from service.
At least I have a right to claim my.
And he has also preferred another writ application against the order of dismissal.
No, that is there. That's not
Same petitioner.
Same order.
Lordship, sir, I can agitate that.
That's what we said here. Same order.
Item 42.
May it please, madam. Let me refer to the notice dated 26/8/2012, my lord. 26/3/2012, my lord, page 19. This is the notice, my lord, second so-cause notice. Prior to that, at page 69, we have informed them, my lord. This was a notice that you have not constructed the residential colony over there, my lord. We have already communicated them that at page 69, my lord.
Yes.
69, my lord, that we have already completed that project. We have annexure 9, we have stated so that we have completed that project, my lord.
My lord, in the impugned so-cause notice, as I find the sole ground of issuance of the so-cause notice is that you have not completed the structure and there is as such there is a violation of the lease condition. Now they have filed a rejoinder affidavit on 14th August 2022, and they are claiming that they have completed the construction of the residential building over the leasehold property. And during this stay period, because there was a stay initially, and this is the rejoinder, and it is a year-old show cause notice. Your Lordship may say that if further cause of action arise, we will, if there is any breach of license, lease condition, we'll issue show cause notice.
All right. This show cause notice has gone infructuous.
Right.
No, not infructuous. In view of this development, your Lordship,
26 March 2012 was stayed with this court on 19th April 2012. And that interim order has continued till date. That is for almost 11 years. Full stop. In the circumstances, it is directed that in the event that the
your Lordship may kindly record certain observations that this is the reason for which we have issued there, and they have stated in so-called rejoinder affidavit that they have completed. That is why.
Because in 2009, we have also given them a letter, my lord, that we have completed that building.
One of the reasons for the show cause notice was that the petitioners had not constructed the building within 60 months from the date of execution of the lease deed. Paragraph. In a rejoinder filed on
14th August
2022, it has been pointed out by the petitioners that they have complied with the aforementioned conditions, and therefore the basis for the show cause notice has disappeared. Full stop. This is not disputed by learned additional government advocate.
No, my lord, this is what they have stated on the basis. I have not seen this is under affidavit he has stated.
Two submissions, my lord.
This rejoinder was filed on 14th August 2022, and there's nothing placed on record to contradict the above assertion. But in the circumstances, it is directed that if hereafter it is directed as under 1, the impugned show cause notice will stand quashed. 2, in the event that the opposite party authorities find that there is any breach of the terms and conditions of allotment, any further breach of the terms and conditions of allotment, it will be open to the opposite party authorities to proceed against the petition in accordance with law.
That's
much of petition is disposed of in the above terms.
That's fair enough.
Item number 43.
No instruction. No instruction.
All right.
Item 44.
1, 2, 3. None appears dismissed.
Item number 45.
None appears dismissed.
Item number 46.
None appears dismissed.
I am for the opposite.
Item 48. 47 only taken. Item number 48.
None appears dismissed.
Item number 49.
49, may I please, ma'am? Petitioners have filed this writ petition challenging the non-payment of compensation after acquisition of land. Lord, may I kindly see the last order passed by this honorable court dated 25/7/2022. My lord, the state was instructed to file a further affidavit updating the current status of the matter, my lord.
All right, Mr. Manthi seeks and is granted 8 more weeks to file the further affidavit in terms of the order dated 25th July 2022. List on. July.
Item number 50.
None of this is missed.
On the point. Item number 51.
50.
51.
50.
He's in 50.
50. 50. Item 50.
What do you want to say?
50.
50.
Please.
So it's a matter regarding land acquisition. We are the below poverty line persons.
is it bunch of case, 10 people. We are belongs to the BPL category. I mean landless, and our land we have applied for settlement of land in our favor. We have enclosure. We are cultivating some government lands for our bread and butter. For that, we have applied before the competent authority, means the Tahsildar, for a settlement of that land in our favor. But in the pending disposal of that matter, that land is been taken by the ITCO for giving to as a lease basis to the Visa Steel. Yes, sir, Visa Power. Visa Power.
This is government land.
Yes.
We have leased out to IDCO. IDCO in turn gave it to Visa Steel. They are saying that we are unauthorizedly occupying, so we are entitled for compensation.
We have pending disposal of
and we have applied for lease. Your application will not strengthen your case
it is in
as
process.
an encroacher.
It is in process.
On what basis are you making this claim, sir? What is the legal basis for the claim?
Because we are the landless farmers and we are cultivating this land for our bread and butter. For that, we have approached the competent authority.
Are you in possession, sir?
Yes, we are in possession.
It is already given to the factory. Factory is running there. And it cannot be used for any agricultural purpose. Once upon a time, you are for government land, you are occupying for agriculture.
And last occasion, the IDCO has, the opposite IDCO, taken time to file the counter.
No. For all that. The prayer in these petitions is for directions to the opposite party state.
So last time it is given time to the IDCO for filing the counter, and still then they are not filed. Counter not received.
And
not
copy also served since 2016.
So not served upon us. We may file before the court, but not served upon us.
The challenge
last occasion we have taken time.
The petitioners who admittedly were encroachers on government land is that the allotment made in favor of IDCO should be quashed. Of the land in favor of IDCO should be quashed. Correct that. During the pendency of the present petition, there was no interim order passed. Mr. D.K. Manthilan, AGA, informs the court that the land in question already stands allotted by IDCO in favor of Visa Power Steel, is it?
Visa Power Private Limited.
Visa Power Private Limited, which is already having its unit on the land in question. The question of, in the circumstances, the question of quashing that allotment in favor of Visa Power at the instance of the present petitioners were admittedly encroachers does not arise. Equally, the question of compensating the petitioners for the acquisition of the said land, for the allotment of, compensating the petitioner also does not arise. Most of the court is therefore unable to grant any of the release prayed for. Petitions are dismissed.
Item number 51. Item 51.
None of this is dismissed.
Weekly item 52.
Page 26, the input.
Labor Court Award.
Two contradictory awards, my lord. Similarly situated persons, two contradictory awards. And by following the principle of first come, first go principle, that he being a surplus employee, he was retained from service. And in this illustration, Annexure 3.
1 minute. Was there a stay granted? There was a stay. All right. Complying with 17B?
17B is complied.
Yes. Complied.
Yes.
So you've been paying them for how many years now? More than 10 years.
Yes. I have seen that.
Might as well regularize a service to take work from them, sir.
He has been retained by because of that surplus. He is a surplus employee.
Even RGA, now if you pay those wages, you'll have to pay more.
Then my lord, I'll take instruction what can be done.
That's right.
Yes,
Lordship.
I'll take instruction.
May
All
I
right.
pray, your lordship? Lordship, first of all, 3 posts of chainman are vacant.
Chainman.
Yes.
Ah,
He was working in the post of chainman.
chainman. Okay.
and
How old is he now?
He's at about 50.
All right. Let him find out then. Let him find out.
And your lordship, there were 3. He's not a surplus workman.
Mm.
They are juniors to him, those who are continuing. I can even name them, your lordship.
No. Name the means you filed an affidavit.
I will file an affidavit.
So you do that in the meanwhile. Let him take instruction. Stay on board.
Item 53.
Obliged.
My lord, I am VC for opposite party.
None appears to the petitioner. Dismissal not possible. All right.
Item 54. 54, my lord, I pray for an urgent because Mr. Bag is ill, my lord.
Who's ill?
Mr. Bag. Bansi the Bag
All
is
right.
ill. He
All
requested-
right. To stay on board.
Item 55.
The memo is taken on. No instructions dismissed.
Item 56. 55 sub item 23117 2013.
None appears dismissed.
Item 56.
Lordship, item 56, Lordship. In fact, my prayer was without approval of, in compliance of Article 243JD, the municipality had taken a decision, but subsequently they have filed an affidavit that they have withdrawn, Lordship.
So it's infractuous then.
But Lordship, the second case is coming on my way, Lordship. Because Lordship, in the connected case, in fact, Lordship, that case also be dismissed since long. As it,
There are 2 cases.
two cases, Lordship. Can the second case, Lordship? In view of the decision of the municipality, first case can be disposed of because that has been my.
All right. In the first case, that is Subhash Padi. Subhash Padi, correct?
No, first case, Lordship, is Satya Behera.
731.
Sorry. Sushant Behera.
Sushant Behera, sorry.
All right. In Sushant Behera, you say the resolution which was challenged by the petitioner has since been withdrawn.
No, madam. It's not withdrawn. So this decision, this petition to create a vending.
So why don't you come to that mic? Okay.
The decision to create a vending zone is taken by the NSC, and it has sent to government. Government, if it is approved by government, then only it can be possible. If the government is not, the government has not given us any instruction till that. Then thereafter, we have filed another resolution. If the particular place in the market, if you won't give because there is some gochar land, some prohibited land, there is no absolute prohibition. But if it is not possible for the government, give us another government land by which we can create a vending zone. That is our rule. But anything it is all depend on government's approval to it. Then only
No. But since you sent a subsequent resolution,
yes,
the earlier resolution can't hold good.
Yes, my lord.
All he's saying is since there is a subsequent resolution and he has challenged the earlier one, his challenge does not survive. I don't know why you should have an objection.
No, I don't have.
So at his statement, let us dispose of his petition. I don't think you can have a problem on that.
No, madam. That's no.
You see, Mr. Dalai points out that the resolution which has been challenged, a resolution of the Balugaon Notified Area Council, which has been challenged in the present petition, has been superseded by a subsequent resolution. In that view of the matter, the present petition has been rendered infractuous and is disposed of as such. Now, what is the second petition?
Second petition, Lordship, kindly see, order dated 15/7 or 16. In fact, it was dismissed on 15/7 to 16.
No, it's filed by somebody else.
Somebody else. But
So same result today also.
Lordship, they have encroached upon the government land
Today,
in the name of.
none is appearing for them, sir.
None of that.
Then that's all at the end of the show.
But clarification must be there, Lordship. Otherwise, Lordship, they are creating hindrance there, Lordship. Lordship, there's some peculiarity, Lordship. What they have done, Lordship, because there is a dismissal order and it has been attached to the present date application. But now they are saying that interim order, still we are continuing. That's why the municipal not taking any action.
Now
it is to be clarified. It is to be clarified, Lordship, only because that is Lordship's board, Lordship. That is the Lordship's board. But that adjustment suffice, Lordship, because that has been dismissed.
It's a disposed of case. So as it is, it's a disposed of.
Not dismissed. Only dismissed.
That's all right. It's over. It's
Lordship,
not.
Lordship only that adjustment.
That's okay. No need. It's a dead matter. That's all. It was just kept here for reference. That's all.
Then Lordship may only have urgent certificate for both the orders, Lordship. Both the
that you can apply for. How can today we pass?
Because it is dismissed in 2016, Lordship.
All right. This matter you say urgent certificate. All right.
Item 57.
In connection with item number 57, 57 infructuous because the account was settled and closed.
All right.
I am for OP Miller.
All right.
Item 58.
My lord, 58 is cancellation of lease.
Cancellation of lease.
But prior to cancel,
you are the subsequent purchaser.
Same order.
Mr. Monty?
Yes, my lord. Let me see.
All right.
The resumption is 98. He purchased in 1991.
All right.
Yes.
On the short ground that prior to passing the impugned order.
My lord, this impugned order was passed
June
by additional
1998.
Tahsildar, I think, na? Additional Tahsildar.
In WL case number 349 of 1985. The Tahsil, this is a
Tahsildar's order, not ADM.
I know.
Under
The
section 3 of the
Bhubaneswar
OJ.
did not issue notice to the present petitioner, who is a prior purchaser under a registered sale deed. But the said order is hereby set aside. And the said WL case 349 of 1985 is restored to the file of the Tahsildar Bhubaneswar, where it will be listed. Is the Tahsildar there or is it now some additional Tahsildar? You were saying something the other day.
That's Tahsildar.
Tahsildar, all right. It will be listed there on 8 May 2023. Stop. The petitioner will appear on that date before the Tahsildar, along with a certified copy of this order. The Tahsildar is requested to pass a reasoned order after hearing the parties and dispose of the said case within a period of 4 months thereafter. There's no interim order here. Okay, till such time, status quo shall be maintained.
Status quo.
All the connected cases.
All the connected cases.
Item 59.
May I please, your lordship? No, the order under Annexer 6. An order passed by the Endowment Commissioner purportedly under Section 25 of the Act for eviction.
There's some appeal against that.
No. Here I challenge on the ground that Section 25 is not applicable to this case because it is a Jagir land. And in a previous eviction proceeding, there was an observation. Your lordship may kindly come to.
Now, 1 minute. Who's for the other side?
Endowment Commissioner. Advocate.
That's the standing counsel for the.
Yes, Mr. Nath is not here. What your lordship is passing order usually in this case, because after this section 25 order, there is a provision that he will send it to collector who will cause eviction of the occupants. And thereafter a remedy lies on the person concerned to file a suit, section 25 subclause 3 of the OHRE Act.
Provided it is a case under section 25. Page 12.
That can be agitated in the suit.
No, he
itself.
cannot.
That the jurisdiction.
He cannot, because section 25(3) your lordship may kindly see. It is for establishment of my rights.
If you go for a suit, you can also raise this question before the civil court regarding your absolute title of the property.
Land. It is a Jagir land.
Whatever the nature of the
deity or not?
Yes. It is a Jagir. Page 12 of the brief, your lordship may kindly have a glance. In a previous proceeding for eviction, that was the observation. Last line, my lord. From the CS Khatian of the year 1930, it is seen that the disputed lands under Khata number so and so have been recorded as Jagir in the name of BC Jena and others. The opposite parties are the descendants of the record of Jagirdars. If the OPs are not performing the service as alleged by the petitioner, but still then the remedy lies under section 24. And 24, my lord, the authority is different. 24 collector is to decide and 25 commissioner is to decide. And 25 your lordship may kindly say it is in violation of the sanction. If there is a illegal alienation, then 25. And 20,
no, but the whole scheme is like this. Just read 25.
Yes, madam.
If you're aggrieved by the order of the collector,
yes,
you're supposed to go to the civil court.
Yes, my lord. But provided this power under section 25 is exercisable by the commissioner.
That can be.
My humble submission, just a minute, please. My humble submission, the appropriate course is section 24. And the authorities are different. Had there been same authority, only a change of section may not have any difference in my claim. But 25, the commissioner will decide, and 24, the collector will decide. So the DT has to approach the collector because it is a Jagir land.
Are you still in possession?
Yes, my lord, by virtue of an order of
and what do you do on that land?
Status quo order was there.
No. What are you? You're the Marfatdar or what are you?
I'm a Jagirdar, my lord. Successors of Jagirdar.
We are cultivating. Or you're just.
Yes, my lord. In lieu of some service.
Where is this land located?
Indrapada.
No. Is it the town or is it a village or what is it?
No, village, Baichuan. Page 10 is the ROR.
And you're cultivating. You're cultivating now.
Yes, ma'am. We are in possession. We are continuing.
My lord, it may be stay on board. Let the endowment commissioner's lawyer.
And also get some Tahsildar has filed an affidavit.
In his presence, your lordship may pass.
All right.
Hey, I'm going.
All right.
Two more.
All right.
Item number 60.
I think we'll stop with this. We'll stop. We'll continue later. All right.